Greetings and welcome to the Saco City Council meeting for Monday, May 17th, 2021. Call this meeting to order at 6:30 p.m. Let the record reflect that all councilors are present, including City Administrator Canrath. At this time, the council would like to invite everyone to join us in the Pledge of Allegiance. The flag is located behind City Administrator Canrath. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you, everyone. There's a slight amendment to the agenda. There was the mayor's proclamations are up under general rather than under consent agenda items. For some reason, there was a mishap with the agenda. So I'm going to read the two proclamations, which will take care of and make their no consent agenda this evening. The City of Saco is pleased to announce that we have been designated a Tree City USA city for the 11th year in a row by the Arbor Day Foundation. This recognition demonstrates the commitment that the Saco Parks and Rec Department has to ensure that Saco's urban landscape remains rich with a variety of tree species that are vibrant, healthy, and safe. Arbor Week in Maine is an excellent time to spotlight the work done by our parks team and the dedication to keeping trees a vital part of Saco's community landscape. The Tree City USA program has been greening up cities and towns across America since 1976. It is a nationwide movement that provides the framework necessary for communities to manage and expand their public trees. Saco joins a select number of cities and towns in the state of Maine that share this recognition. I will now read the official Arbor Week proclamation. Whereas in 1872, J. Sterling Morton proposed to the Nebraska Board of Agriculture that a special day be set aside for the planting of trees. And whereas this holiday called Arbor Day was first observed with the planting of more than 1 million trees in Nebraska. And whereas in 1978, the state of Maine first celebrated Arbor Week during the third full week of May. And whereas trees can reduce the erosion of our precious topsoil by wind and water, cut heating and cooling costs, moderate the temperature, clean the air, produce life-giving oxygen, and provide habitat for wildlife. And whereas trees are the renewable resource giving us paper, wood for our homes, fuel for our fires, and beautify for our community. And whereas trees, wherever they are planted, are a source of joy and spiritual renewal. Now, therefore, I, William Doyle, Mayor of Saco, do hereby proclaim May 17th through May 21st, 2021 as a celebration of Arbor Week. In the City of Saco, I urge all citizens to celebrate Arbor Week and to support efforts to protect our trees and woodlands. And further, I urge all citizens to plant trees to gladden the heart, promote the well-being of this and future generations. The next proclamation is Building Safety Month. Whereas our city is committed to recognizing that our growth and strength depends on the safety and economic value of the homes, buildings, infrastructure that serve our citizens, both in everyday life and in times of disaster. And whereas our confidence in the resilience of these buildings that make up our community is achieved through the devotion of vigilant guardians, building safety and fire prevention officials, architects, engineers, builders, tradespeople, design professionals, laborers, plumbers, and others in the construction industry who work year-round to ensure the safe construction of buildings. And whereas these guardians are dedicated members of the International Code Council, a nonprofit that brings together local, state, and federal officials that are experts in the built environment to create and implement the highest quality codes to protect us in the buildings where we live, learn, work, play, and whereas our nation benefits economically and technologically from using the international codes that are developed by a national voluntary consensus codes and standards developing organization, or government is able to avoid the high cost and complexity of developing and maintaining these codes, which are the most widely adopted building safety and fire prevention codes in the world. And whereas these modern building codes include safeguards to protect the public from hazards such as hurricanes, snowstorms, tornadoes, wildland fires, floods, and earthquakes. And whereas Building Safety Month is sponsored by the International Code Council to remind the public about the critical role of our community's largely unknown protectors of public safety, our local code officials, who assure us of a safe, sustainable, energy efficient, and livable buildings that are essential to America's prosperity. And whereas prevent, prepare, protect, building codes safe. The theme for the Building Safety Month for 2021 encourages all Americans to raise awareness about the importance of safe and resilient construction, fire prevention, disaster mitigation, energy conservation, water safety, training the next generation, and new technologies in the construction industry. And whereas each year, in observance of Building Safety Month, people all over the world are asked to consider the commitment to improve building safety, resilience, and economic investment at home and in the community, and to acknowledge the essential service provided to all of us by local and state building departments, fire prevention bureaus, and federal agencies in protecting lives and property. Now, therefore, I, William Doyle, Mayor of the City of Saco, do hereby proclaim the month of May 2021 as Building Safety Month. Accordingly, I encourage all citizens to join with their communities in participation in Building Safety Month activities. Thank you very much. Those are the only two proclamations. That takes care of general. Are there any committee correspondence at this time? See no hands raised. Moving on from committee correspondence. That brings us to item 6 of the agenda, public comment. City Administrator Canrath, have we received any public comment for tonight's meeting?
Not at this time, Mr. Mayor.
Thank you very much. At this time, I'll open it up to members of the public who wish to speak to the council. Please use the raise hand feature of the Zoom platform or *9. Up first, we have Ron Giles. Ron, you've been allowed to unmute. Please go ahead and do so. State your name and address for the record and present your comments to the City Council.
Yes, I'm Ron Giles. I own the property where the KFC sits as of today. And I just have some concerns with this property here. And let me just try to go as fast as I can to let you know. The building itself, that they want to tear it down and put a new one up and put 3 businesses in there. And one of them is, pardon me how I pronounce it, Chipotle, and the other one is Jersey Mike's. They are fast food, and then a retail one. If you look at this lot, and if you look at the drive-through that they have, okay, 1 lane, and how it's going to go to a pickup window, okay, exit out in the front. Now, with that said, you're also going to have people exiting in, going up to the, on the left-hand side, to the front to see if they can get parking up there. And then what happens if it's full, they're going to have to try to back down, okay? It's going to create a really traffic problem up there. Now, also, if you look at them coming in on Smith Road, okay, then they're making a left-hand turn, all right? Now, with the KFC there, and if you remember, I don't know if some of you were around when we did that 15 years ago, we put the easement in the back, so it took care of the credit union, now the dentist, which was supposed to be CVS, and to make a nice traffic traffic lane. Now, this is going to create a problem with them coming in left-hand side. And if you also look, is that they're closing off the so-called easement that has been used for years. In that, as far as, I guess when Dunkin' Donuts was there. And Dunkin' Donuts was allowed to use that. And there was an agreement, I believe, that was made years ago that gave Dunkin' Donuts and the other one, the coffee place, Starbucks, and to exit out in there. But on this, they're showing, as far as I can read, they're going to do away with that. Now, this is the same plan that he showed the planning board last week. I don't believe I've seen any revised plan, okay, on this. So I would just say that they're saying, look, they're not going to do anything there. And just, I guess my whole concern is really take a hard look at this before we make a decision of a contract zone. And I thank you very much for listening to me.
Thank you, Ron. Okay, there are no other hands up. Moving on to item 7. There is no approval of the minutes. There is no consent agenda item. That brings us to item 9 rather, and that is action items. And right now, it is my great pleasure to bring on the planning board and to invite the planning board up to be panelists. And then we are going to do a joint meeting with the planning board that's going to consist of legal training. This is the first time that since I've been a counselor and now mayor that both the council and the planning board are going to get trained at the same time on different things. And so I think that's imperative, and I'm going to keep that moving forward for the next couple of years so that one of the 2 required trainings by the 2 bodies, or one of the 2 required meetings of the 2 bodies, one of them will be a training so that we're all keeping up to date on changes in the code and changes in different laws. So welcome to the planning board for joining us on this Monday night in this joint meeting. Okay, and now we're going to promote, Denise Clavette is, Director Clavette is already promoted. We're going to promote. I think we're all good. All right, everybody's here, so welcome. Thank you for all joining us. And with that, I think we're going to go, because we have a full agenda, we're going to go right into the training. So Director Clavette, please lead us off and down this road.
Thank you, Mayor Doyle, and thank you, Chair Gerard, and members of the Planning Board, members of the City Council for this joint meeting, which tonight will be providing a joint workshop type training session. As a matter of fact, for a new, whether it's Planning Board or Council members, that it will also serve as the mandatory FOA training as well. So you won't have to sit in a separate one as well. So this evening, we put together a really great program, great outline. It'll be conducted by attorneys, which I don't believe have been promoted, or I'm just not seeing the gallery if they have. So I think we need to promote attorneys, and I'll introduce them now. Mary Beth Costigan and Phil Saucier, both great land use attorneys with Bernstein Sure. They've provided similar trainings for other councils and other planning boards throughout the area. And I'm waiting for them to show up.
They have been promoted. Denise.
They have
So
been promoted. Okay, great.
they're in the Brady Bunch boxes.
They're in the Brady Bunch boxes. Okay, there you go. 1 or 2. My screen has now been expanded. Awesome. But we worked together with Bob Hamblin and with Isabel Exley, Bob, our city planner, and Isabel, our planning and economic development associate, to put together this program, which essentially covers a lot of the finer tuned aspects of board governance and ethics and site plan review, development review. And so without much further explanation, I would love to turn it over to both Phil and Mary. And again, I'm going to do my best to monitor the Q&A chat feature, unless Mayor Doyle, you want to manage that, but I thought you may want to just be paying attention. But that's it. I'll defer to you as to what you want me to do. I'd be happy to field the questions and facilitate, so you can participate, but that's completely up to you.
Thank you, Director Clevitt. That sounds like a great idea.
Okay. Well, thank you very much for having us. I'm Phil Saucier, as Denise said, and my colleague Mary Costigan is here. We're both in the municipal department at Bernstein Shore and represent a number of towns. And I mostly work with public clients, although we do represent some private clients from time to time. And we've been asked to just do a training for both boards. And so I'm going to go first. And we did submit a brief outline of how we're going to go. So I'm going to go, and then Mary's going to do FOA, and we're going to kind of go back and forth on the topics, is what we're going to do. So I'm going to start with what I called conducting the public's business or expectations of a public official. And this first presentation is really general in nature, but really some points that we've really learned over the years about some things to kind of help move things along, some general governance questions, and also to try to keep you out of court, or if you're in court, to put you in the best position to succeed if you're challenged. So these are fairly general, and we're going to have a couple like that. FOA is a fairly general, and some conflict of interest discussions. But then we were asked to kind of talk a lot about land use. So you'll see some, even though the council's here, there is some overlap, and I'll get into that with the council on land use. And so we'll have a little bit more of a focus on that as the presentation goes on. But first, in this sort of general discussion of conducting the public's business, standards of behavior applicable to public work, some of these are going to be very just tune-ups for everybody, but I think they're important to always remember, which is, and the first one really is that the public officials, and some of this is going to sound almost cheesy to me, but in this day and age, I think it's really important to talk about, is that your first priority is to serve your municipality, its mission, and to fulfill your legal duties. And in doing so, you set aside personal feelings and priorities that should not be influencing your actions. Clearly, the council has a little bit more of a role in policymaking, obviously, but at the same time, we don't let bias or conflict or predisposition get involved. And I'm going to get more specific discussions about that in a moment. You have a fiduciary responsibility to serve your city in a fair, impartial, unbiased, and civil manner. And I think that's very important. And to treat people with respect. And I know everyone in Saco does, and I've appeared before your boards, and it's always very respectful and courtesy and respect. But that makes a big difference, because there are certain boards, quite frankly, today that don't act that way. And it's where you see things start to go off the rails. If people don't feel like they are being heard, or if they're being disrespected when they're in front of your board, and it goes a long way. That also means part of civility means a decorum of process, working with discussion and motion format, working through the chair, and not letting the meeting become an argument or people directing comments to each other in the audience or amongst each other. Board proceedings are always conducted under Maine's Freedom of Access Act. And as Denise said, we're going to get into that. Mary's going to talk about that in more detail next. And they're open meetings, but that doesn't always mean that people have an unlimited opportunity to participate. And that's something important too. Where there's expected to be a lot of comment, you're allowed to limit the public's participation on certain times, like 3 to 5 minutes, and to keep conversation fixed on the topic at hand. where's apparent, and this is actually I think important. When I was the chair of the zoning board in Portland for a number of years, and one of the things I learned there is even though it can be very frustrating, if there's a topic that appears that there's more time, deference should be made to give it. I found that more process is always better, even if it means sometimes later evenings and frustration. But people should, you should make sure you're hearing from everybody, that everyone has an opportunity to express their view, because when you decide to vote and you vote in a way that maybe they don't disagree, at least most people will understand that you've considered everyone's opinion in that discussion, and you've heard from everybody, and that really does go a long way, oftentimes in stopping an appeal or other kinds of disagreements on a topic. Again, the chair still can, even though I'm saying give deference and allow people to speak, there's certain times though you can ask members of the public to not be repetitive or duplicative. If there's a lot of people at the same time, you can ask people to just move along if they already said it. But on the other hand, I do think you should make sure that everyone has the opportunity to speak if they want to. You should only decide matters. Again, some of this is planning board focused in your quasi judicial role, but you should only decide matters and act upon by evidence that's in the record itself. And public officials should avoid discussing a matter that's in front of your board outside of the meeting. Because, and again, Mary's going to get into this, that not only can violate the public meeting laws, but it can also implicate due process, where an applicant should have the ability to understand where the board is coming from when it makes its decisions. And if that means those deliberations happen in public, so people can hear what you're saying, and there wasn't sort of predisposed of or based on information that they don't know what it was. And that gets to my second point is, even though you should rely on evidence in the record, that doesn't mean you can't bring your own personal knowledge or information. Everyone comes to the table with who you are and what you know. But what you shouldn't do is go out and do independent research on topics. This is where you can get in trouble, and Mary can get into this a little bit more too. Again, this is a due process issue. If you ever do that, and I don't recommend you do independent research, but if you do end up doing independent research, what you need to do is let everyone know exactly what you did, what you read, and give people the opportunity to respond to it and to comment on it. In participating in town activities, you need to apply, and I know you all know this, but it's again another tune-up, apply the law as it is, like it or not. You can seek to revise the law. We have counselors here. So the counselors here can revise the ordinances, amend the ordinances, but you can't apply laws or change the laws and apply them in a way that would circumvent the intent of the law. And I say that a lot when we give this training. We're often talking just to planning boards or boards of appeals, boards that have to apply the law as written, the ordinances as written. And what we often say is, you may not like it, but that is the law. And if you don't like it, then go to your counsel and talk to the council about how you think that the ordinance should be changed. But you certainly shouldn't be not applying it just because you find it distasteful or wrong. That doesn't mean that there's some interpretation, and that's a lot of what Mary and I do, and what boards will do. There is interpretation of the laws, and that interpretation should be logical, however, supported by facts and applicable standards of the body and its purposes. It does not mean rewriting or stretching standards to fit a philosophy, position, or circumstances. What the courts will look at, if there's an interpretation question, in other words, there's a disagreement over what the words in an ordinance mean, is the courts will look first for its natural meaning. Is it defined? If it's not defined, if it's in conflict, it's going to try to find something that's not irrational, an irrational meaning, something that fits in harmony with the overall ordinance. And so that's something that you should do if you're applying a provision that there's a disagreement over intent. Is how would those words, how would those phrases, that performance standard fit in the larger context of your ordinance in a way that would read rationally? Finally, board members and public officials serve under oath of office. We expect our board members to be models of sincerity and honesty. I do know, having served in boards, and Mary has served in boards, I'm currently on another board, that it's hard to be on the firing line a lot. And a lot of the issues you're dealing with can be very high profile, and there's a lot of emotion involved on both sides, and it can be challenging. But it is very important to continue to be as civil and polite as possible, because when applicants do not feel respected, or members of the public who don't like a project don't feel respected, that's where we often see the beginnings of protracted disputes fueled by acrimony and appeals where you may not need to have an appeal. So again, these are very basic concepts that I know you all know, but they really do go a long way when you're trying to avoid appeals and litigation on issues. So with that, I'm going to turn it over to Mary, and Mary's going to go over FOA, and after that, you're going to come back to me to talk about conflicts of interest.
Good evening, everyone. Thank you for inviting us here tonight. My name is Mary Costigan, again with Bernstein Scher. Prior to Bernstein Scher, I was in-house at the City of Portland, where I first met Denise long time ago, and so I've seen the world from your perspective as well. As Phil said, some of the things we're going to be talking about tonight apply to both boards, some one board, some the other board, but I think it's a really great idea that you're both here so you can gain a little perspective about what the other boards are going through. And especially for the council, I know that, you know, if there's a member of the public who's frustrated with something that's going on at the planning board, and they're going to call you up and they're going to say, I don't like what's happening. By sitting through this, you get a better idea of what the planning board can and cannot do and what they're bound by. And I think it's really helpful to have that perspective. I'm going to talk about freedom of access. I know you've probably all had this training before, but it helps to get a refresher. It also helps a little bit to get a different perspective. I'm going to share my screen so I can kind of go through it pretty quickly and have you take a look at it, which is why you see me here twice. One is where I'm going to share my screen from my laptop. So here we go. Okay. Here's the overall purpose of the Freedom of Access Act, and it is to provide transparency and open the business of the city to the people. And so when people talk about freedom of access, we're talking about two things primarily. We're talking about public meetings and proceedings, and then public records. Many times you associate FOA with a FOA request of a record. But when we're talking about FOA, we're also talking about how to hold your public meetings and providing notice, et cetera. That also falls under it. So I'll start first with public proceedings. Public proceedings are the transaction of any business of the city, so any board, commission, agency, or authority of the city. And that's important. You have to have the conducting of the business and the board. And I'll get into why that's important in a minute. And it's because anytime you have a proceeding, it has to be open to the public, unless there's some reason why it would be confidential, primarily executive sessions. So they have to be open to the public, and anyone has to be permitted to attend a public proceeding. When they can be closed to the public is in executive sessions, and then other specific examples, one that you're familiar with at the council level are poverty abatements. So this is, this applies to both boards. A little more so to the planning board when you're talking about an adjudicatory proceeding. But primarily, the idea of having a public proceeding that's noticed and open to the public is that when there are a number of board members, enough to constitute a quorum where business can be conducted, that really needs to be open to the public so that the public can see the business of the city being conducted. And that can be violated. A few of you meet up, you start talking about business, and you say, oops, oh, we probably should not have done that. And email is another example. You can't be emailing as a group unless you're talking about administrative things like when's the next meeting, and we're here in distribution and receipt of materials. But if you have an email correspondence about an actual subject matter that's before your board, that is a public meeting that should be, excuse me, that should be noticed, and is not legal. And I am going through this quickly because we have a lot to cover tonight, and I'm sure you've heard a lot of this before. So here, the public has a right to attend the proceedings. They have a right to record the proceedings. Phil talked about earlier, it doesn't mean that they actually have the right to speak at hearings. It depends on what's happening that evening, but they do have the right to attend and listen. You have to make a recording of the meeting. One benefit of these Zoom meetings, I see the record button up in the left-hand corner. It makes it very easy to record these meetings. Minutes have to be very, very sparse. They don't really have to have a lot of information, but the recordings these days that are available digitally really help to preserve these public meetings. Executive sessions mostly apply to the council. Planning boards rarely have executive sessions, but sometimes if there's usually to meet with their attorney, if there's a real issue that's a confidential matter to discuss, whether there's litigation threatened or pending, that's typically when you would meet with counsel in executive session. Here's the list of permitted executive sessions. The ones that we're mostly familiar with are when you have an attorney present, personnel matters. Here's executive sessions, the rules here. Can't be used to defeat the purposes. The most important, a couple of takeaways about executive sessions is there's no voting. If you do vote on anything, that is actually null and void. And of course, anything that happens in executive session stays in executive session. That's sometimes an issue depending on the body and the individuals involved. Public notice for public proceedings, reasonable notice. At the beginning of the pandemic, as you all know, there was legislation to allow for virtual participation, which has really, as much as it's nice to be in the room with folks, there have also been some benefits, and there are multiple bills in the legislature now to allow that to continue, because currently the virtual meetings, the ability to participate virtually would end 30 days after the emergency ends. But I imagine that this is something that's here to stay. It's really given a lot of people the opportunity to participate who may otherwise not go to City Hall or turn on the television. And it's been a great way to allow people to participate. Making a record of your decisions. This is also a FOA requirement. It's about putting folks on notice about why and how the decision was made. Now we're on to public records. I just flew through that, and hopefully you've all had some of that before. So public records, anything written, printed, graphic, mechanical, or electronic information that's in the possession of the city and that's been received, prepared in the transaction of public business. What's important about this, kind of a bigger takeaway, and it's usually for the person who's in charge of FOA, but it's really important to remember, is that all three of these things have to be met, and it has to actually be written graphic information. Many times people will submit a freedom of access request, and it's a list of questions, and they want someone to answer all of their questions. Well, it's really not up to, it's not under the guise of FOA. information, it's to provide information that exists. So for example, if somebody has a list of questions, if there are public documents that they can review to get the answer to their questions, then they can review those documents. And I say that because a lot of times there's some frustration with members of the public who think that FOA means that every question that they have needs to be answered within a particular amount of time. And that would be difficult for staff to have to do that while doing their regular duties. There are some exceptions, of course, to public records, most notably personnel records, juvenile records, but there are not a lot of exemptions. Violations, you can be taken to court for alleged violation. You can be fined, and yes, anything that's happens in executive session, if it was an illegal meeting, it will be null and void. I'm going to stop sharing my screen because I'm going to come back and talk about application review. But Phil is going to jump back in. I forgot to mention that if anyone has any questions as we go along, kind of at the end of each section, you can ask questions now, or we can wait until the end.
Great, not seeing any questions, so I'm going to move on to conflicts of interest. So conflicts of interests are there's both there's this case law and there's statutes that govern conflict of interests. But the general idea here, and it gets back to what I was talking about as part of my initial presentation, is that fundamental due process under state and federal law requires that actions of a public organization be undertaken and completed in an open, fair, and impartial manner. And that means we cannot act with any bias or predisposition, actual or perceived on most matters. That includes financial, and that we must step aside or refrain from acting on an application, even if there is the appearance of a conflict of interest. And so I'm going to talk a little bit about that, about the statutory conflict of interest. So there's a Maine state statute that applies to municipal entities, and it's in 30A 2605. That's the conflict of interest statute you'll hear about from time to time. And what that statute says is that that it defines a conflict situation, what I'd call a per se conflict, financial conflict. In other words, if you meet this test, you must step aside. And the test is this: if the municipal official, so that the board member or the council member is a quote officer, director, partner, associate, or stockholder of a private corporation, business, or other economic entity that has something before that body, so an application, a license application, and that board member is directly or indirectly the owner of at least 10% of the stock of that company, or at least 10% have an 10% interest in the business or economic activity. So it's that you're an officer or partner shareholder, and you have at least 10% ownership. If that's the case, that's what I would call a per se conflict. You have a statutory conflict of interest, and you must step aside. If you don't step aside, the decision that the board made while you were sitting on it is voidable. So someone could bring a case and then void the whole decision. And that means a contract that was awarded to an entity and a site plan approval that was awarded, it can void the whole thing. So it's very important that if you have a financial conflict, as I just described, it's very specific, as defined by statute, you should step aside. There's also that statute also talks about avoiding the appearance of a conflict of interest. And that's when you may not meet the 10% test, but you could still have some financial self-interest in the outcome in it, or at least there's the perception that you do. In other words, maybe you're an employee of the paving company that is asking for a contract from the city. You're not a shareholder, you don't own 10% of it, but your bosses do. And that could be a perceived conflict. In the example I just gave, that seems to be more fairly obvious that it's a good idea to step aside. There are other cases that are a little more gray and not so clear cut. So that you perceive conflicts could be that you are you've done business with a company. You don't actually own the company or work for the company that's applying for you, but maybe you have a business relationship with that company. You do business with them. Those can be a little more gray. And what you should do in those circumstances is ask yourself, can you participate in that proceeding without any bias, predisposition, or by letting your relationship impact your participation or decision in that case? And can you make a decision based solely on the record of the proceedings and your best judgment in applying the applicable relevant standards? If the answer in your mind, and again, this is a little bit up on each individual to go through this analysis. If the answer in your mind is no, I can't. I'm clearly, I am predisposed I to do this, then you should step aside. If, on the other hand, you think to yourself, no, actually, I do have a business relationship with that person. I know them. Maine is full of small towns. We know a lot of people, and we come across people. But you think you can be unbiased. You can review that application without predisposition or letting your relationship impact it. Then what you do in that circumstance is you announce it publicly, and you say, look, I do business with Jane. I've done business in the past with Jane. I'm not currently doing any business with her now. I know her. I have nothing to do with this application. And in my view, I can participate in this proceeding without bias and predisposition. You let the board then discuss it if they put that up for discussion, and then you actually vote if everyone agrees to allow that person to continue to sit on that application. That's how you handle those kind of conflicts. It puts it out in the public. It allows everyone to understand. You disclose, which is the key here. You disclose that any perceived conflict and why you think you're unbiased. And then that way it's known to everybody and it's not being hidden. I oftentimes will even recommend, if you're like at a planning board, for example, and it's a close call, but you really do want to sit and you really think you have a predisposition bias, is you not only let the board speak, but you sometimes ask the applicant themselves if they have any issue with you continuing to sit on that application. And the reason why is because this is an issue, and Mary's going to get into it in one of the lessons learned cases. Predisposition or bias or conflict of interest is one of the areas that you can attack a decision if you bring an appeal. So it can be to the detriment of that applicant if they think that maybe there is some sort of bias or predisposition, and they don't want that clouding a decision that you may grant for them. So that's why you sometimes ask the applicant too, do you see any issues here with me continuing to sit on this board? And then you move forward. But really just sort of disclosure and vote is how you deal with that. There's also another kind of conflict, which is called bias or predisposition. I kind of got into that under the statutory appearance of conflict, but there's a general idea of bias or predisposition as well. Again, and I've kind of gone over it, but this is something that you should also not, in addition to what I've already talked about this issue, is that you should not be independently investigating applications, or not only is that a due process issue and a potential FOA issue to go out there and have meetings, but also it can also be, people can raise that as bias, that you're somehow looking into an application in a way to try to find something to defeat it in a way that's not part of the record that was presented to you by the applicants and the members of the public. So you should not do those kind of independent investigations for predisposition or bias. There's also another kind of per se conflict, which is called familial bias. And there's a statute, it's 1 M.R.S.A, section 71(6). It's what we call a disqualification statute. So you cannot sit on an application, you cannot sit on a board when you're reviewing an application when the person is related to you. And this gets us back to, and I love this word, back to my Wills, Trust, and Estates class in law school, within the 6th degree of consanguinity or affinity. What that really means is your great-grandparents, you're inclusive, including cousins, uncles, and I think it goes out to second cousins. But basically, it's all your relatives that you would know. You should not be sitting on those applications, and that could also disqualify you and could potentially void void the application if someone challenges it. And again, finally, the failure to abstain is that a court could declare your vote void if challenged. I also know, and Denise just asked me to mention this, that in addition to the statutory conflicts and case law, municipalities can adopt their own code of ethics and conflicts of interest provisions. And I know that the city just went through an amendment process of your own conflicts of interest provisions. I'm not going to get into the detail of that. I understand you guys have gone into the detail of that relatively recently through the amendment process. But really, I think it's best practices for a municipality to go even further than what that sort of minimal really provision under state law is, and that's what you did to really get to the highest ethical standards and to protect employees and members of the public from unethical and illegal behavior. I understand that it's that this was reviewed by your legal counsel, adopted last year, and everyone here should familiarize yourself with that policy. It's really a team effort to make sure that everyone acts in an ethical way as defined in your policy. So I'll just leave it at that. But there is a local policy on this as well. Is there any questions before we move on conflicts of interest? Seeing none. Moving along, I've got the next section too. And this is called the powers and duties. This is important. It's a fairly brief presentation, but it's really important because boards only have the authority to act in areas that they have the jurisdiction to do so, either under state law or municipal charter or ordinance. Boards cannot act what we call extra jurisdictional. You cannot take on matters that you do not have the authority to do so. And in this way, it's nice to have these two boards here together because these two boards have different powers and duties, different jurisdictions. I'm not going to get into broadly what the city council does. The city council is the municipal legislative body for the city. Unlike some of the towns we represent that have town meeting towns of government, which the town meeting itself is a legislative body. And so there's a very broad areas of authority that the city council has to govern. But what I am going to talk about really is the intersection between the two boards and the types of work you do on planning and land use. As I mentioned, the city council, I'll go with city council first. The city council is the legislative body for the city. But it does have a number of roles related to land use, zoning, and planning. Under state law, the city council has the authority to adopt the comprehensive plan. It's one area that you have. That's the plan that guides the direction of the city. It is the document. It's not a regulatory document, the courts have said, but it is the guiding light, if you will, for the regulatory documents. It's the precursor to adopting any land use or zoning ordinances. Any land use or zoning ordinances have to be consistent with that comprehensive plan. So it really is the guidepost that the city, what the city wants to see itself in the next 5 to 10 years. So that's one of the things that the city council has the authority to do. The city council also, as the legislative body, has the authority to adopt and amend the zoning ordinance under state law. And so the city council really is the policy body when it comes to land use and planning, setting out the rules and regulations for the orderly development in the city. The city council also, and I know you've dealt with this recently, is adopt contract zones if authorized by local ordinance, and your local zoning ordinance does authorize you to have contract zones. Contract zoning is really a form of zoning. It's under the zoning statute. In fact, it's a specific type of zoning. But that authority is given to the city council. There is substantial deference to legislative determinations by the city council when it comes to those three areas I just mentioned, because the courts do see the council as the legislative body, and the courts have said we will defer to those legislative enactments as long as, when it comes to zoning, contract zoning, and zoning, that it's consistent with the comprehensive plan, that what the area that you're rezoning is consistent with the existing and permitted uses there's in the underlying zone, and that you're only including conditions, again, about contract zoning specifically, conditions and restrictions that relate to the physical development or operation of the property. The courts have consistently upheld the ability of a council to zone and contract zone areas. It's very difficult to overturn a decision of a city council. And there are many cases, including a case out of Saco you might be familiar with, called Golder versus City of Saco in 2012. And that was one of the many cases that have essentially deferred to the decision of a city council on a contract zoning determination, as long as you met those three standards, and the courts found that you did in that case. And there's many cases like that when it comes to challenges to zoning ordinances and contract zoning ordinances. The city council also, and I think this is one of the final areas really in land use and planning, is you also appoint the members of the planning board and zoning board of appeals. So that's a significant power that you have. However, once you appoint those members have their own duties, and the city council does not get itself involved in the areas that the planning board has jurisdiction to oversee. Under state law, the planning boards are actually there's not a lot in state law that really defines planning boards and the authority of planning boards, unlike zoning boards. There's a zoning board statute, for example, and it says specifically what a zoning board can do to grant certain types of variances. Only those kinds of variances are allowed under state law, and things like that. There is no general planning board statute. There used to be many years ago, but there is not anymore. I think the word planning board actually only shows up in one place, and that's in the subdivision statutes. It says the planning board can act as a municipal reviewing authority. But there are two areas. So it's subdivision approvals. Planning boards serve as the municipal reviewing authority, and also planning boards, through the role as the municipal reviewing authority, which is the term that's used in statute, is the body that holds public hearings on proposals for zoning amendments, including contract zones. So in amendments to zoning ordinances and adoptions of contract zones, the planning board has a role of holding a public hearing. That's the role that they have on those provisions. Under state law, it doesn't even say they give recommendations, but typically under local ordinance or custom, sometimes the planning board does give their opinion on the amendments or the contract zones, but ultimately the council has the authority to adopt zoning ordinances and contract zones. But that's a statutory role that the planning board has, is to hold public hearings on those types of things. Under the city zoning ordinances, that's where you see planning boards get their authority in most towns in Maine, are their local ordinances. And your local ordinance have given the planning board a lot of different jobs to do. And I know you just recently amended your zoning, site plan, and subdivision ordinances and clarified a lot of provisions. But I just want to tick off a few areas. I know you guys know this, but obviously site plan approval is one of the main jobs you have. Master plan development, conditional use permits, shoreland permits, subdivision review and approval. There's also a couple of sort of interesting sort of one-off provisions, like approving changes to from one non-conforming use to another non-conforming use, as well as making certain decisions when it comes to reconstructions, relocations, or replacements of a non-conforming structure. But again, those are specifically defined and given to the planning board as part of their powers, and that's why they can act. They cannot act if they do not have that power in the ordinance or statute. And we sometimes see boards try to do things that they don't have the authority to do, and the courts will almost always overturn those decisions if they didn't have that authority. There's a case that's not exactly on point, but some of you might know the DeFoss versus City of Saco case in 2015. That wasn't really, it was a jurisdiction case, but it was about who had the authority to where appeals were taken. And in that case, it was an example of where the court wanted your ordinances to be very specific over where the roles are, what the jurisdictions of these various bodies are, because if not, it creates confusion for people. And I know you've read, but I've still, and I don't mean to pick at a wound, but I always love this expression. The court said at that point, the court thought your ordinance were a quote, imbroglio of confusion and contradiction. And I've always thought that was a funny term, but I know you have rewritten them and cleaned it all up. And so we're not in that world anymore. So we're in a good place. The final thing I'll say about, well, actually I already said this. I was going to talk about how you would interpret those ordinances. I mentioned that briefly, but what the courts have said is you interpret these ordinances once, and that includes jurisdiction, reasonably with regard to both the objectives sought to be obtained and the general structure of the ordinance as a whole. So again, you try not to define something when you're looking at jurisdiction or you're looking at performance standards in a way that just wouldn't make sense in the context of the overall ordinance. That's a general principle of interpretation. So that's what I have on powers and duties. Do I have any questions about that? Okay. I don't think so. So we're on to the next topic, which I think is Mary.
That's me. Okay, I'm going to share my screen again. Oops, I'm going to skip. Sorry about that. Okay. I'm going to talk about application review. So this is really going to be directed at the planning board, but I'm sure there are some takeaways, little gems in there for the council. So as Phil just talked about, these are the primary applications that the planning board would review: conditional use, site plan review, subdivisions, shoreline zoning, master plan development. You generally have a similar application review for all of those. What I have here is just a list of sort of, bigger takeaways. My role here is not to sort of pick apart the way the actual process, but really talk about the bigger picture and the bigger takeaways. And especially in a city like Saco, where there's some pretty complicated development. Both Phil and I practice around the state, on both sides of the table, if you will, whether we're defending the town or assisting the town, assisting planning boards with review, and then also representing clients in front of towns and cities. I happen to do a lot of work in the city of Portland on the applicant side. So I have a lot of experience with the Portland Planning Board from the applicant side of the table. Very familiar with, what it's like to interact with staff sort of before we get before the planning board, and important takeaways from there, and how that relationship works and how it can work ideally. So the first thing we'll talk about here is that this, and I have some court cases intertwined here, that the planning board's decision must be based solely on whether the applicant has met his or her burden of proof and complied with the provisions of the statute or ordinance. Phil alluded to this earlier, but this is really the big takeaway, which is for a planning board, you have a set of criteria that the council has decided should govern applications. And your job is to take in the information that's presented on the record, and based on that record alone, determine whether the criteria established by the council are met or not. It sounds easy. It's not always that easy. But if you find yourself in a position where you may not think a particular development is in the best interest of the city, or you may disagree with the criteria, or you may wish that this wasn't happening, you really need to just turn off that side of your brain and just focus on what's in front of you and whether they meet the criteria or not. As Phil said earlier, if you don't like the rules, you need to change the rules. You can't decide that you don't like the rules and make a different decision because you don't like those rules. It's just not permitted. It also gives you, I'm sure there are many times you have upset members of the public who don't like a particular development. And the response to that is, these are the rules. And this applicant happens to meet all of these criteria in order to have something like this not be approved in the future, go talk to your counselors and see if there's a change that can be made. But if, when you're thinking about an application, you're thinking about not only the rights of affected members of the public, abutters, et cetera, but it's also the rights of the applicants. So an applicant has the right to have some transparency and some predictability and know a set of rules and know that if their application meets that set of rules, that they get a permit. And so they put a lot of time and energy into doing that, and they are entitled to a permit if they meet all of those decisions. The next piece is something that Phil talked about a little bit as well, which is that decisions shall be based on the evidence in the record and not evidence obtained through ex parte communications or otherwise outside of the record. Ex parte communication in a planning board setting would be a planning board member speaking directly with an applicant. So that is not permitted. And also you should not be gathering evidence outside the record. If you happen to do that, you would come back to the next meeting and say, hey, I happened to, Google phosphorus loading because I didn't understand what it meant. And this is what I found. I only say that because I had a recent example of that with someone in a lakeside community who was researching, and they did that. They brought it to the meeting and talked about what they found. But in a city like Saco, where you have a sophisticated staff and you have people who are working with the applicants, the best way, if you don't feel you have the information that you need to make a decision, you ask the staff or you ask the applicant to bring additional information to the table so that you can better understand it. And then that same information is brought to the board in front of everybody. And then that information is part of the record and your decision is based on the record. The next point is that when there's a proposed project that complies with all of the ordinance requirements, the board must approve the application. I said that before, just reiterating it again, and it was in this case and many other cases where if the statutory criteria are met or the ordinance criteria are met, then they get an application. The next point is also important. I work again in Portland a lot, and applicants spend a lot of time with staff, just making sure that staff has all of the information they need in order to provide all the information to the board that the board needs in order to make the decision. The ultimate decision is absolutely in the hands of the board, but the members of staff who have been working with these ordinances, who have planning backgrounds, other engineering backgrounds, whatever their backgrounds that they bring to the table, they've been interpreting this, they have history, they can provide a perspective that can really assist the board. And they have, technical expertise that, if presented in a record, in this case that I've quoted here, that the court does give deference to an ordinance interpretation of the staff and an opinion as to whether an applicant met the criteria sufficiently. Many times, I know in Portland, the board report from staff, they will say whether they think a certain criteria has been met or whether more information is necessary. Again, it's ultimately the board's decision, but if you have a report in the record and evidence in the record that supports the finding that all the criteria are met, but the board decides that the criteria is not met, and then there's an appeal and it winds up in court, it's going to be difficult to defend a decision when all of the record evidence is supporting a finding that the application met the criteria, particularly when you have a staff report that says it has. So just keep in mind that the court will look at the staff opinions and give those opinions deference. The next section subject I want to talk about is conditions of approval, because this comes up a lot, where I don't know how sometimes boards tend to take liberties with conditions, I guess is the best way to put it. You have to keep in mind that conditions of approval have to be reasonably related to a standard of review, and they have to be necessary. So I'm just trying to think. So maybe you have a typical site plan standard is impacts on neighbors and buffers, right? And sometimes there's a condition of approval that you have to create a vegetative buffer. But that condition has to be one that is related to a condition, a standard about visual impacts on neighbors. It has to be a requirement to put a reasonable buffer in that meets the criteria. So it would have to be that without such a condition, the standard could not be met. So you really, that condition has to be related to the fact that you're not going to be able to find that standard is met unless you put this condition on. You may have a very cooperative applicant who would agree to other conditions that may be a nice thing to do to appease a neighbor. And we all see those. I don't know if you do this frequently, but I see it in Portland where sometimes the neighbor's like, I really would rather have the fence be red. Well, it's not really related to a decision criteria, but sometimes an applicant will just agree to do something like that to have good neighborly relations. But those types of conditions really do need cooperation from the applicant, because they could appeal that type of condition if it's not reasonably related or necessary. Okay, I'll keep going. Oh, there was, I didn't have it here. On the list of agenda items, there was also the master plan development. I didn't have a separate slide for it, but if you have questions about it, I can tell you that in Portland, it is a useful tool. I imagine it's used similarly in Saco, where it is just a way for someone who's developing a larger or more complicated development or phase development to allow them to take advantage of a process that benefits both parties. So the town gets some knowledge and predictability and a way to manage a large development. The developer gets some predictability and gets to essentially lock in zoning, if you will, of the densities and styles of what's happening at the time of the application, and gives them some parameters and predictability to work in. But I'm happy to answer any questions that you might have on this topics. And then Phil and I can go to lessons learned.
Mary, Matt Provenzel here.
Yeah.
Just a quick question on the decisions and the information provided by the applicant. What would be an acceptable time frame to request material? Let's say the board and an item gets tabled, and the applicant comes back and we're still looking for information, or maybe the same information and we're not quite satisfied. How many times would be acceptable for the board to continue to ask for more information or more clarity without receiving it before a decision be made?
Yeah, that answer is going to be it depends, but the way many planning boards work, and I imagine Saco is the same. I have not done a lot of work in front of your board. You continue to work with an applicant so they can get to a place where their proposal meets the criteria, because you like to see them be able to make use of their property in a way that's compliant with the code. But at some point, you're going to realize that it may just not get there, and it may be that they either, if they're not able to provide you the information that you need in a timely manner, then it just means that you need to make a decision. And at that point, if they get the understanding that if the board is not satisfied with the lack of information, and that they need to provide certain information in order to demonstrate compliance, then maybe that'll make them act. But there really is no set, time frame. So I've seen sometimes, a developer would just say, I've provided everything. I think I meet the standards. Please make a decision. And then if the board makes a decision that they would deny the application, then it just goes to court.
Okay, thank you.
Yeah. Any other questions? All right, it's an easy crowd. Phil, do you want to? I'll talk a little bit about lessons learned. I was involved in a case, and this is on the topic of ex parte communications. I was involved in a case, and I was on the applicant side, and it was a very controversial project, and it was approved by the planning board, and it was appealed to the Board of Appeals. This happened to happen at the Board of Appeals, but it would apply to the planning board. And it was pretty clear from the beginning that a couple of the board members were not happy that the planning board approved it. And they were pretty difficult throughout the process. And we learned through circumstance that at the end of the process, before a decision was made, that two of the board members did have ex parte communications, not with the applicant, but with the opponents. So, but in a Board of Appeals setting, they are a party because they were the ones who appealed. So they had ex parte communications with a party, with the appellants. And they also did a site visit all on their own and didn't bring any of the information. I'm going to side note, we didn't talk about site visits at all, and I'll talk about that for a minute. And we just learned that this was happening. And they still we asked them to recuse themselves. They stayed in, and they granted the appeal, which meant that the application was denied. We appealed it to court, and those were the first counts. And it did not take the town attorney long at all to recommend to the Board of Selectmen that they settle, because they knew that they would not win and we'd have to start all over again. That was it was a really pretty egregious example, but it was a situation that went through a long time at the planning board and a long time at the Board of Appeals. And the actions of these two members would have had us start all over again. And so the town settled instead, and it was a fine result, if you ask me. But really, the development did comply with all the criteria, and it went forward. The other, from a procedural perspective, case that I was involved in more recently, actually the court did hit on two procedural matters. That's good to just confirm, and they have to do with conflicts. The one situation was that the applicant in this other case was actually on the planning board, but he owned property in town and owned a business, and recused himself from the planning board, stepped down, got behind the podium, and started presenting his application. And the board approved the application. Of course, the neighbors appealed and said that's unfair. He can't do that. And the court said, this is Maine. We have small towns. We want people to be able to volunteer for boards, and we can't stop them from advocating for themselves and applying for applications. We can't force this person to hire a lawyer or hire somebody to represent them in front of the board when, you know, they have every right to do that. We did have all of the board members before the presentation said, I have not in any way been swayed by this person to have me vote in a certain way. And so the court said that was perfectly acceptable. The other thing in that case was also a notice and due process issue, where the planning board did not provide personal notice to an interested abutter. They weren't necessarily required to, but this abutter was very, very active, and they did not provide them personal notice. So what the board did, they called me and they said, what do we do? And I said, hold another meeting and let them talk. You know, I mean, like Phil said, just let people be heard. It doesn't necessarily mean that if they had appealed, the town would have lost on that issue, but it just stops, you know, having a count two is a due process claim. In this case, they did have a due process claim, but the court said that by holding another meeting, allowing them to speak, cured any due process violation that may have occurred. And so, you know, there's different ways to correct things. If you feel that someone is, you know, really not going to stop, they're going to go to court because they don't feel like they've been heard. If it's not too much trouble, just let them be heard. You never know what you might hear, and they may feel satisfied and not be taking the city to court. Phil, do you have any lessons learned you want to share?
I was just going to bring up one, and then we'll take questions. And I was thinking about, I do the legal year in review for the Maine Bar Association every year for the municipal cases. So I have to go through every single municipal case and present them. And what I was trying to find one the last 2 or 3 years to deal with planning boards. There's actually really not a lot. A lot of them happen to be in the zoning boards, get appealed a lot, code enforcement decisions and enforcement cases, things like that. To the extent there's a planning board cases, Mary just talked about one of them. It was CASA case where we're the town attorney there. Mary had that case, but there's one I found it's just a practice pointer because it's coming up more and more. So I thought I'd bring it up. It's for the planning board, and that's a standing issue that it sort of gets to the issue of one of Mary's topics, which is what are the important things in an application review. And actually what we call the threshold questions. One of them is jurisdiction, what I went over. So it's threshold question when you have an application, do we have the authority to review this application? The second one is standing. Does the person have the right to bring this application in front of us? And what the courts have said, and your ordinances even said, you have to have something called sufficient right, title, and interest in the property to be able to use that property in the way that you are asking permission to do so. So you have it, and that means you have a deed, you have a purchase and sale agreement, you have a lease, you have something that gets you in the door to say we have right, title, and interest to bring this application. It's been sort of black letter law in Maine that planning boards and zoning boards and councils, for that matter, when they're dealing with contract zones, are not in the position of deciding private property disputes. And what that means is if someone comes and they say, I've got the right to build that development, here's my deed. And someone says, no, you don't, because there's a declaration of covenants over that, and it says you can't, or there's an easement that they're saying it can't be used in that way. What the courts have said is, well, that's not in the purview of municipal bodies. You don't have the jurisdiction to decide that. Those are private property disputes. And all you need to decide is, look, do they have a deed or not? Do they have a right or not? To the extent there's a disagreement, they can bring that to court privately and argue about it. That's sort of black letter law in Maine. The Tommasino case out of the town of Casco last year changed that a bit. On one hand, the court said, and in that case, just at what was going on there was a development for a new house, but part of what the access was was an easement to get to that house, and they needed to clear some trees to be able to get there. And they asked for a shoreline permit. and to be able to clear those trees. And the underlying landowner or the co-owner of the easement, there are two parties involved. The other party said, these people don't have the right to clear the trees. And the Casco, in that case, it was the Casco zoning board. But then this appeal court said, that's not, because there's a private property dispute, that was not sufficient right, title, and interest to move forward. And so that's a little different than what we've always viewed this. And there was a dissent in that case. You don't get a lot of dissents under the Maine Supreme Court like you hear at the U.S. Supreme Court, but there was a pretty vociferous dissent. And Justice Connors said, while she agrees with the majority in that case, that a municipal zoning case is not the proper forum for a private property dispute between neighbors, and questions of property law are outside of a municipal board's jurisdiction, that case would have the effect of inviting rather than discouraging municipal boards to wade into private property disputes, and will result in needlessly protracted proceedings involving squabbling neighbors. And because what that case said is, if there is a disagreement over whether someone has the right to use the property in the way that they're telling you they can, they need to go get a private court action interpreting that easement in that case, or declaration or covenants in that case, and bring it back to the board to move forward. Now, we don't know how far this case is going to go and whether it's limited to the set of facts in that case, but it's something that I've been talking to a lot of the planning boards that I work with. I get questions more and more now about that in the boards that I represent. And if someone says, if there's a disagreement about it, how can the board rely on that easement, that deed, or not, if there's a disagreement? So that's something you'll want to work with your city attorney with from time to time. You'll probably see more of those disputes. So that's one case that's come up. But we'd be happy to take any questions about any of this. We kind of went fast. It's within our time limit here. I think we're 8 o'clock or so. Denise or Bob, is there anything that we didn't cover you'd like us to cover? Happy to do so. Oh, Michael has his hand up.
Yeah, if you don't mind, I have a question about, I think you called it ex parte communications.
Mhm.
And in my role as a counselor, it's very rare that an agenda item comes up that I don't hear from interested parties about.
Right.
And I'm curious when that becomes an inappropriate ex parte communication, and when it's inappropriate constituent talking to the representative about it, and how that works.
Sure. Yes, it's very different with an adjudicatory body or a quasi-judicial decision you're making. So as a counselor, those situations are rare, but decisions that you would make, such as issuing a license, right? You issue liquor licenses. In that situation, because you are acting quasi-judicial and actually making a decision and issuing a license, it would not be appropriate for you to be talking directly to the license holder or licensee or applicant. That would be an ex parte communication.
And what about things like contract zones or approving of results from planning board decisions?
Yeah. So in a contract zone, also you have an applicant. So to the extent that you would be talking to that applicant, that would be an ex parte communication. You're not making an adjudication, but I think if someone were to challenge that decision, they could claim that you were somehow biased in your decision making. It's not as cut and dry as if it were if you were adjudicating a matter. You are making a legislative decision, but someone could argue that that legislative decision was swayed and not based actually on the criteria necessary in determining whether to issue a contract zone.
Thank you.
And I'll take your second question, which I think you said, if someone disagrees with the decision of the planning board and they're writing to you, that's an example of where those are two different areas and two different bodies, and the city council has no authority over the planning board when it comes to their decisions. And I think that's important to understand that. Constituents don't always understand that. And they just know that there's an application that's in front of the planning board. But what I always say to the board, this council present, is if you get questions, it's fine for you to take comments, obviously, take comments on anything. But you just simply say, look, the city council doesn't have jurisdiction to hear that. That's a site plan decision. It's in the planning board. Direct your comments to the planning board, and to the extent that they have the standing to do so, they can appeal a decision if they don't like it to the court, which is the next step. But the council really has no role in an application itself. The council just adopts the ordinances that the planning board applies.
Thank you.
Don.
Phil, Mary,
Yes, go ahead. Sorry.
this is Bob Hamblin. How are you?
Oh, hi, Bob.
Good, Bob.
I've enjoyed the presentation. To me, much of the past hour revolves around, or this rose to the surface for me. I took a picture of that screen. It was decisions. The planning board's decision must be based solely on whether the applicant has met his or her burden of proof, etc. I thought, I don't really have a question, just an observation that I thought of everything that's been covered. I would hope Saco planning board members focus on the 4 bullet points there. I think it was stated clearly, and you might not like the ordinance, but if that's what the ordinance says, then that's what you must abide by. You don't like the ordinance, set about changing the ordinance, but if it's in black and white in front of you, that's what you must abide by. And I do not think we have any issues or concerns with that currently, but great guidance, I think, for planners and planning board members, both present and future.
Thank you, Bob. Because, it does sound, it is, when you break it down, pretty simple. It is so easy when you have a really complicated, potentially controversial application in front of you, and there's a lot of emotion, and you kind of get caught up in that. And it helps the planning board member as well as the member of the public to understand that there's a set of rules, there's evidence, there's the application, there are the materials, and if the standards that are in the ordinance match up to the information that's being provided, it's really out of your hands as a planning board member. If the decision criteria are met, thou shalt issue a permit. It's just the way it works. And it does help to break it down, to put your job in that perspective, and also to explain your role to those who may not be very happy with your decision.
Good point. Thank you.
Thank you. We have 2 hands up, Don, and then Marshall, maybe Phil too. But Don first.
Thank you. One thing that came up with the Saco Planning Board not too long ago, the attorney for the applicant actually submitted a request in writing to have, I guess he suspected that there had been ex parte communication between some members of the planning board and possibly, as I understood it, some opponents to the project as it was being, proposed. The attorney requested in writing to the planning board that each and every planning board member was to stand up at one of the meetings and declare that they had not had ex parte communication, in the process. My position on that is I balked at that, obviously, and took the position that if the attorney for the applicant thinks there's been some wrongdoing along the way, he'll have an opportunity to explore that under appeal if he thinks that's appropriate. But I'm just interested in what your take is on that, Phil and Mary, given that you're in the profession and having him submit that in writing. We did not respond in writing to him. And I just ignored the request and moved on, with getting the planning board to move through the process. What's your take on that? I'm interested.
Well, I can answer that only from the perspective of the situation that I talked about earlier. The way I handled it was I knew who the individuals were, so it was submitted as a request for them to recuse themselves from the decision. and that just prompted a conversation, and they had a conversation. The board decided that they were going to stay in and continue. So what it was a request for a recusal because we knew the specific individuals, and it also was an attempt to actually, if they had recused themselves, we wouldn't have a basis of appeal on that issue, but they decided to move forward. So some of it really, the response to that, regardless of how the request is made, sometimes a response may, prevent litigation, or in this circumstance. So when there's an appeal from a planning board decision, it's under this Rule 80B. You've probably heard of a Rule 80B appeal, okay? It's primarily appellate review, meaning that we just write briefs and the court decides it based on the briefs. But there are issues such as a claim of ex parte communication or bias that could trigger a separate claim and could trigger a trial at court, because they would have to be presenting evidence. So it does set up sort of a larger court process that if it's in your control to try to stop that from happening, it may be worth just kind of putting up with those requests sometimes, just so it doesn't turn into a big trial and waste a lot of time. It certainly is an unusual request, but it's not always fun to have those types of issues being litigated if it could be handled quickly. Phil, did you have something to add?
Yeah, in my observation, I think that's right. I also say though that you're absolutely right, Don, that you don't have to respond. That's not, you don't have to respond to members of the public, or even applicants for that matter. I mean, your job is to apply the ordinance to the application that's in front of you and not get into a colloquy back and forth. So I agree that you have the discretion not to do so. As Mary said, sometimes if it's an easy thing to do, then you can, if it's something you put to bed really quickly, but you do not have to respond to those kinds of requests. Sometimes attorneys will write, and I don't know anything about this particular circumstance, but sometimes Mary was sort of getting to this issue, which is to be able to raise, if someone really thinks there was a conflict of interest or there was a ex parte violation, they have to preserve that argument, but if they want to appeal it further. So you'll sometimes see lawyers write a letter so that it's in the record. And then they can, so that they can then, if they do take an ADV appeal, they can also say, oh, and by the way, we also think there's a conflict of interest. If they didn't do that, then it would be likely that a judge would say, you waived that argument. You didn't raise it below. And so you waived it. So sometimes when you'll see lawyers do that, they may not even want you to respond, or they may not want to even get into it, but they're preserving arguments. And I can tell you, I don't do as much private work as Mary does, but I do some, and I've done some in front of you guys, but I'm more on the public side. When I am in front of a board that has an issue, I can tell you it's not always an easy thing to say to a planning board, particularly when you're asking them for approval. And to say that you think there's a biased member or there's a conflict of interest. And it's a delicate task for attorneys sometimes to be able to preserve that for the record, but also preserve the relationship, knowing that you want them to, continue to review your client's application in an unbiased way. But that could be something that you'll see from time to time, the preserving the argument. We talked a lot, but the short answer is you don't have to answer those questions. Yeah.
Marshall, you have your hand up?
Yeah, Marshall, yeah.
Yeah, thank you.
Oh, you just muted yourself. There you go.
Here we go, double click. I just want to build off of Councilor Burnham, again, using that counselor perspective with ex parte communication. So we're going back a little bit because we had some extra questions come in. I'm just looking for clarity on, and I'll provide an example, clarity on when does ex parte communication start, especially with a counselor representative of the people approach, because in a lot of cases, I consider myself a mentor to the public, where they come to me, they ask questions, they're not quite sure what they're going to do. Part of our job is economic development. So we do talk to business leaders, things of that nature. When does, I see it as perfectly okay. A person is like, hey, I'd like to start a new business in the city of Saco. How do I do that? What's your take? What's the market look like? Is this viable? I have no problem asking that, especially when it's a constituent who's just trying to get information. does ex parte communication exist then, or only at the what's the word to say? Once the application is submitted?
Yeah, the vast majority of what you do as a counselor does not trigger ex parte communication and prohibition. You're an elected official. People elect you because you have opinions, because you have insight, and you can absolutely express those opinions and have those conversations. The example that I gave, because you as a body, you don't do a lot of quasi-judicial issuance of licenses. But if someone were to come up to you and say, hey, I just opened a restaurant and I'm looking to get a liquor license, wink, wink, come on, you really like, what can I do to get that license? When you're actually like making a decision that impacts, that's actually you're making a decision, you're giving someone a license. That's an ex parte communication in the context of a quasi-judicial proceeding.
But speaking to the clerk, you need to go to the clerk's office, being very instructive, not
right. Yeah,
not
exactly. You can
Is
tell them
there-
how to do it, right, but not
Who to talk to.
who
Yeah.
to talk to.
And
Anything
if
like
it's likely to become a contract zone amendment or something to that nature in which it would need council approval, is there a timestamp, or do we not talk about contract zone amendments?
Maybe I'll go on this one, Mary, next.
Yeah.
Because you had mentioned that. Contract zoning is a little bit more difficult. It's not like a license to me. It is a legislative determination. But it happens to be a legislative determination with a specific applicant, right? Unlike an amendment to the zoning ordinance that has general applicability. That's clearly policy and legislative. It affects everybody. In my view, there's no quote ex parte violations when you're talking generally about zoning. Okay. It's just a little bit more of a gray area when you're talking about contract zones, because although it is a legislative body, you have someone who's actually asking you for something specifically. In sort of in the guise of an application to the planning board. It's a somewhat similar concept. So I think you just have to be, Mary, I don't know, add to this, but I think there can be general discussions. You're going to hear from neighbors, you're going to hear people from the public. That's part of your role as a counselor. But then if it gets to, okay, I want you to do that, before I vote, I want you to do this, this, and this. And, it starts to becoming more of a quid pro quo kind of discussion. That's the line, I think, that you need to be careful of in that. Is there anything else, Mary, on that?
I talked about it a little bit earlier, which is because it's a legislative act and it's not adjudicatory, it's not as black and white. However, if somebody's not happy with the decision and they appeal, it just becomes count two, right? It becomes, you didn't make this decision this way because you felt that it was consistent with the comp plan. You made this decision because you went to high school with Joe. Joe called you, and it gets to be about that. The best way to head that off is when you go to the council meeting and you're talking about the contract zone, you say, listen, Joe called me up. This is what we talked about.
Disclosure.
I didn't get any other information. It's all about disclosing conversations and disclosing information so that it doesn't appear that you're somehow biased, because it becomes more about a bias issue as opposed to some sort of violation.
Thank you.
Yeah. Anyone else? Phil Hatch.
There we go. I sit on the council for clarification. I'm swimming around the appearance of conflict issue, and where do we draw the line when it comes to issues that come before the council for vote, and the individual who's before us could be part of a social circle that you actively engage, but yet you or I as a counselor can say there has been no lobbying, no effort on any level to try to influence my vote, but yet that that appearance is there because there may be others in the community who know what that social circle involves. So I'm just curious, how do we sort of deal with that effectively?
Well, I mean, as I mentioned, the best way to deal with it is discussion, is disclosure and discussion. The worst way to deal with it is to ignore it. So if you're part of a social circle and people know you're part of a social circle, and there's an appearance of conflict issue, even if there's not a real conflict or technical conflict, people are going to think that, and they're going to think the worst, essentially, and sort of they won't be confident in your vote. So what you really should do, and I do think there are a lot of those instances, particularly in Maine, we're small towns and we know each other, that doesn't mean you need to not vote on things. And I always say that doesn't mean you have to abstain if you really can be unbiased. You don't know, you may know these people, you may know the issue, but no more than anyone else in town, and you can do it in unbiased and without predisposition. Then say that. Then just say it at a open meeting and say, I know these people. I hang around these people. I am not part of this application. I don't have any bias, and I just want to put that on the record. And I'd like people to vote. And then the council then would vote to agree with you or not. Mm-hmm. But typically, if you are, they're gonna trust that you're being honest, and they'll vote to do it. That's what the courts have said. Essentially, it won't always necessarily 100% cure the issue, but it essentially cures any challenge to bias, because you're just being upfront and you're being open about it. So,
thank you. That was a very good answer.
You're welcome. Thank you. Any other questions? No, Alyssa.
And you'll have to. I did not kind of study ahead of time who's on the planning board and who's on the council. You have to forgive me for not calling anyone by counselor or their title. We're just calling everyone by first names, and I just realized that I'm doing that, so I apologize.
That's more than fine for us. I'm on the planning board, and my question, I think, is a best practices question. I'm curious because both of you work throughout other communities in the state. We see a number of applications every year that end up going down the route of an appeal or something further after they leave us. And I think a few months ago, I realized, we really don't have a common practice in Saco of circling back to those situations and finding out what inevitably happened after that appeal process, went underway. We don't really have a process of learning from it, understanding what part or, what part of our process was, problematic potentially. So I'm not sure what other communities are doing throughout the year for more frequent trainings and specific to actual applications that we've seen. So true, like real life examples that we could be working with.
That's a really good question. And I think
a good question.
It really is. The one thing I will say, and Phil alluded to it, is that we generally see a lot of appeals of zoning board decisions. Planning board decisions are not as frequently appealed. It doesn't mean, they certainly are. But many times if I'm involved in appeal, whether it's a planning board or zoning board, many times they're upheld. But if they're not, or if there's some difficulty, the lessons learned many times lie in the actual decision document and the findings. And so one example is that the result, it was a town that did not utilize us very frequently up front and always kind of came to us at the end when they got in trouble and they were in court. And it was at that point, it was too late, right? And so I worked with them on a guidance decision document so that they could follow it, and so they could get their, it's important to get your findings on paper, but it's just as important, if not more important, to actually, if you have that as a guidance document, you're actually talking through the different standards. And really, when you're working towards getting something in writing, you're processing it, and you're, as a board, talking about, okay, let's see, how did they meet the stormwater requirement? All right, what information did we have? They gave us this, they gave us that. Here's the standard. And if you're talking through all of that in order to get it on a piece of paper, it means you're doing your job, or you're actually going through that exercise. So if someone then goes to appeal, the court's going to have the record of the discussion that you've had, and they're going to have the actual written finding that you made on that specific standard. So the most important thing that I've learned, after the fact, if something is for some reason not upheld, it's many times related to how they got to this decision and whether there was sufficient evidence in the record to support that decision. And the way you get there is to really methodically go through the standards and talk about it.
Yeah, I would say some of the same things. And the other thing I'd say is also, that's a good question, because I don't know of any board that does what you are saying you should do. And it's a good idea, which is to maybe as sort of practice more than anything, to say, if there's been an appeal and you have a final disposition by the courts, I think it's a great idea to say, let's have a briefing on that, at least to say sort of, what did we learn from that case? Is there anything we could have done differently? I would wait till the case is finally done, because you don't want to interfere with the case in any way. But I think it's actually a great idea. I'm not aware of that actually happening on a routine basis with any of our clients. But yeah, I was going to say something Mary already took, so I'm not going to. The biggest issue you see planning boards are findings of fact. You guys don't have that problem. You've got good staff. There are towns with no staff, and so sometimes you will literally see approved, and that's the whole findings. And the court, when Mary and I get a case like that, we're often brought at the end of the case. And what the thing we say is, and I've done this a lot recently to be efficient for the municipality, is to agree right off the bat with the plaintiff's counsel to have it remanded back to the planning board to develop findings of fact. Because we know it's a year's going to go down the line. The judge is going to say the same thing. We've wasted time and money. So that's the biggest thing, but you've got good staff who are helping you with written findings and stuff like that. That's one of the biggest things. The other final takeaway, just because you have staff on here, I work with a lot of planners and code enforcement officers, and I have a little joke with them, is what every time we have a little issue that we don't know the answer to and are arguing about it, or a plaintiff's lawyer is saying, they disagree with interpretation, I always say, put it on your amendment list. And I have my code officers have an amendment list, or planners amendment list. And so every time you see something that is an issue because people are disagreeing over the meaning of something, fix it, because it's going to happen again. And so just have a list. And I know it's hard to do amendments, and sometimes it takes months, but if you have a list of things you need to get fixed, you can maybe head that off again next time if the language needs to be cleaned up or something like that. So, all right. There are no other questions. I think that's all we have. Thank you very much for having us here tonight.
Yes, thank you. Hopefully this was helpful. Denise, or anything we missed that you want us to add?
I think you covered quite a bit of ground tonight, high level, and I think it's been appreciated. And I think if we have any other questions, we'd be happy to direct them to you. Unless any of the counselors or Mayor Doyle have any questions, or planning board members have questions, I think we're good.
Good. Well, thank you.
Thank you very much.
Thank you for joining us.
Have a good evening.
Okay, thank you very much, everyone. Thank you to Phil and Mary for a good presentation and a lot of information in there to digest. At this moment, before we move on to the next agenda item, is there anything that any member of either panel wants to discuss in our joint meeting? Again, we're supposed to have 2 of these a year, and moving forward, one of them will be a training of some sort. So with that, I want to thank the planning board members for giving up another night in a week to be present and give back to the community. So thank you very much. With that, have a great evening. Okay, so the next item on the agenda is item B. It's a public hearing for Chapter 118 updates. Councilor Berman.
Yes, thank you, Mr. Mayor. At the Coastal Waters Commission meeting on January 12th, 2021, the commissioners approved two proposed amendments to the Chapter 118 Harbor, River, and Waterfront Regulations dated March 17th, 2014 for consideration and adoption by the City Council. The first update is in Section 118.5, Paragraph H, Item 2, which changes December to November. The reason behind this change is that after December 1st, recreational boats become a hazard. Owners have abused this cutoff and left boats to freeze in the water. This causes hardship on the harbor master, who must monitor these vessels until they are removed. November 1st deadline would not infringe on anyone's recreation and would relieve this problem. The second item to be addressed, also in Section 118.5, is for the use of City of Saco courtesy moorings in the newly added Paragraph K. The reason for this change is that at present, the City of Saco provides two moorings at the Cocktail Cove area of the river to allow river users to tie up for lunch, fishing, or swimming. Overnight tie-ups are permitted, but should not be abused, as has been the case. 2 years ago, one person occupied a mooring for almost the entire season. The harbor master requires a basis on which to prevent this occurrence and abuse of the privilege. Staff recommends approval, and I move to open the public hearing.
Motion's been made by Councilor Berman. Is there a second?
I'll second that.
Councilor Hatch. Any discussion or open on the public hearing? Roll call vote to open the public hearing. Councilor Archer.
Aye.
Councilor Purdy.
Yes.
Councilor Gunn.
Yes.
Councilor Berman.
Yes.
Councilor Hatch.
Yes.
Councilor McPhail.
Yes.
Councilor Johnston.
Yes.
Motion passes 7-0 to open the public hearing at 8:22 p.m. If there's members of the public who would wish to speak to the City Council on the Chapter 118 proposed updates, please use the raise hand feature or *9 of the Zoom platform. Seeing no hands raised, Councilor Berman.
Thank you. I move to close the public hearing and schedule the final reading for May 24th, 2021.
Second.
Motion's been made by Councilor Berman, second by Councilor Johnston to close the public hearing and set final reading for May 24th, 2021. Any discussion on the motion? Roll call vote on the motion. Councilor Archer.
Aye.
Councilor Purdy.
Yes.
Councilor Gunn.
Yes.
Councilor Berman.
Yes.
Councilor Hatch.
Yes.
Councilor McPhail.
Yes.
Councilor Johnston.
Yes.
Motion passes 7-0 at 8:23 p.m. Brings us to item C of the agenda, and that is a public hearing, a zone change request for 97 New County Road, 106 New County Road, and 107 New County Road. Councilor Archer.
Yes, thank you, Mr. Mayor. Applicants John and Linda Fenderson asked that the zoning of their property west residential be changed to rural conservation. The Fendersons own and live on the property at 97 New County Road. They run a small farming operation with livestock and crops. The Fendersons are near, but do not abut the boundary that separates the RW from the RC. The property of their abutting neighbors to the west, Patterson, separates the Fenderson parcel from the WR/RC boundary. The Pattersons own two parcels, one on each side of New County Road, and theirs are the westerlymost parcels still in the WR district. The Pattersons too have requested a change of zoning for their two parcels from WR to RC. This item was reviewed by the planning board at its March 30th meeting. After discussion and a public hearing, the board voted to forward a positive recommendation to the council. During the council's discussion on April 20th, an earlier map showing the potential for a portion of city-owned land to be included in the rezoning was referenced. See proposed solar Fenderson plan. I move to open the public hearing on a rezoning request for the parcels at 97 New County Road and those identified as tax map 87 lot 17 and tax map 96 lots 9, 9 tac 1, 1, 2, and 17.
Second.
Motion's been made by Council Archer, second by Councilor McPhail to open the public hearing. Any discussion on open the public hearing? Roll call vote on opening the public hearing. Councilor Archer,
Aye.
Councilor Purdy,
Yes.
Councilor Gunn,
Yes.
Councilor Berman,
Yes.
Councilor Hatch,
Yes.
Councilor McPhail,
Yes.
Councilor Johnston.
Yes.
Motion to open the public hearing passes 7-0 at 8:26 p.m. Members of the public wishing to speak on this item, please use the raise hand feature of the Zoom platform or *9, and you'll be unmuted to deliver remarks to the council. First up, we have Linda Fenderson. Linda, you've been allowed to unmute. Please go ahead and do so. And state your name and address for the record and present your comments to the city council. Linda, you've been allowed to unmute. Please go ahead and do so. State your name and address for the record and present your comments to the city council. Okay. I think there's some technical difficulties there, folks. We're going to go on to the next person. We'll come back. Next person identified as Ben. Ben, you've been allowed to unmute. Please go ahead and do so. State your name and address for the record and present your comments to the city council.
Hello, this is Ben Patterson from 105 New County Road. My fiance and I, Catherine, own 105 New County Road and 0 New County Road, which I think you got the tax maps right, but 106 New County Road is not one of the ones that was supposed to be part of this. It was 105 and 0 New County Road, which are the two properties that we own. 105 being where the house is, and 0 New County Road being our land that is across the street from it. So just want to make sure that's cleared up for future. Otherwise, we have livestock and I've been farming here. It's been my family's farm for over 100 years, and we just realized that we don't really fit with the current zoning, and having livestock isn't permitted in our current zone. If we change to, I believe it's called R1 now, we abut R1. Not really sure why we were changed to begin with, as we don't have any interest in being residential or going that route at all. I'm only 23, so I have a long ways to go before it's going to be sold. I know that's one thing that the city council mentioned for that is the aging of farmers, but it's not an issue on my end. I actually went to school for agriculture as well, so that's kind of the goal of the property, is to keep it that way. And it really aligns with the goals of the property to be able to continue to be a farm. And we're also currently grandfathered in that we can do the things we do, so it's kind of a little ridiculous that we have to finagle our way around, current farming practices and hoping that the city's going to continue to align and say that we're okay to do such practices. Where if we're in R1, it wouldn't be an issue for us. It's a pretty clear cut there. That's all. Thank you.
Thank you, Ben. We will try Linda Fenderson again. Linda, you've been allowed to unmute. Please go ahead and do so. State your name and address for the record and present your comments to the City Council.
Can you hear me now?
We can hear you now.
Okay. Well, I just heard what Ben said, and I don't understand either why we ever were put in rural residential, since we were a farm and have been, quote, by you folks, grandfathered. And I don't understand how, we could have ever even been put in West residential. This has caused a lot of stress for us, and we're older now, and it really wasn't warranted at all. This long drawn out process to get our property back to rural conservation where we were in the past and where we belong has been really wearing on me, and it'll be such a great relief to me and the weight off my shoulders if we can get this back to where it belongs tonight. I'm praying that this will happen. Thank you.
Thank you, Linda. Up next is Colin Sexton. Colin, you've been allowed to unmute. Please go ahead and do so. State your name and address for the record and present your comments to the City Council.
Thank you. Colin Sexton, actually 83 Bailey Road, Somerville, Massachusetts, here representing John and Linda Fenderson for Blue Wave Solar. I actually had my hand raised because Linda was having technical difficulties and I wanted to make sure she was heard, but rather than paraphrasing anything she said, I think it's really important, just being around the Fenderson farm, that they do continue to be this farming operation that has been seemingly very important to the city of Saco, and that's just from my 2 years of knowing her. Solar project aside, I think this is a really important rezoning for the Fenderson family and to keep this land as a farming use for years to come. Seems to have been an integral part of the community, and I think it should remain that way as a farm. So that's all I have to say. Thank you very much.
Thank you, Colin. There are no more hands raised. Councilor Archer.
I move to close the public hearing and schedule the second and final reading for May 24th, 2021.
I'll second that.
Motion's been made by Councilor Archer, second by Councilor Hatch, to close the public hearing and set final reading for May 24th, 2021. Any discussion? Planner Hamblin, can you address the question that came up during the public hearing about, excuse me, where 106 came from, where is 105 and 0 County Road? And that I believe that Mr. Patterson brought that up. Can you just flag that for some discussion?
Yeah, Mayor, I'll take a stab at it. I have a zoning map, or excuse me, a tax map in front of me. And as the Pattersons know, 105 New County Road is the larger property owned by the family on the northerly side of New County Road. Now, I imagine what is being referred to as 0 County Road is simply the assessing office's practice of until a parcel actually has a building on it, then it is not assigned a street number. So perhaps most easily identified across the street, this would be the larger parcel owned by the Pattersons on the southerly side of New County Road. And as Ben knows, it is not developed. That is, it doesn't have a building on it. So it has no street number assigned, but it is recognized by the assessor as tax map. I believe it is tax map 96, lot number 1. So in this case, it's just easier to refer to map and lot than it is to a street number. A question, if I may, to address to perhaps Ben Patterson. There is also a smaller lot. It is identified as lot number 2 on the tax map that I'm looking at. It is surrounded by the larger lot number 1. I assume it's a house lot. I would ask Ben, is it the intent of the Pattersons to include that in the rezoning? And then, if I may, Mr. Mayor, back across the street on the northerly side of New County Road, again, there's the larger parcel owned by the Pattersons. It is lot 9, and it is 105 New County Road. Again, within that larger parcel, there is a much smaller parcel. Again, I imagine it's a house lot. It's identified as lot 9-1. Is that also intended to be rezoned to RC or rural conservation? If I may, Mr. Mayor, thank you.
City Planner Hamlin, is that something that you can reach out to Mr. Patterson between now and the second and final reading to have those questions answered?
Absolutely.
Thank you very much. Any other discussion on closing the public hearing, setting final reading? Roll call vote. Councilor Archer?
Aye.
Councilor Purdy?
Yes.
Councilor Gunn?
Yes.
Councilor Berman?
Yes.
Councilor Hatch?
Yes.
Councilor McPhail?
Yes.
Councilor Johnston?
Yes.
Motion to close passes 7-0 at 8:37 p.m. That brings us to item D, which is actually, it's not a first reading. MOUs are only require one reading, so it's a first reading and final reading all in one. But Councilor Archer.
Yes, thank you, Mr. Mayor. Berry Road, which consists of both an accepted city street, roughly 4,400 feet, and an unaccepted way that is used and maintained for current residents, would be improved to city street standards for roughly 880 feet under a proposal submitted by Linda Valentino. The work would commence at the westerly end of the accepted portion of Berry Road and would provide access and frontage for her and other properties. She would then submit a plan for planning board review for a 7-lot subdivision, including a new street and existing parcel under her ownership. As a result of council discussion during the April 12th meeting, the city attorney has prepared a draft MOU for this evening's review. Be it ordered that the city council authorizes city administrator Kenrath to enter into the Berry Road Memorandum of Understanding. I move to approve the order.
Motion's been made by Councilor Archer. Is there a second?
Second.
Second by Councilor McPhail. Discussion? So if one of the questions at the last meeting on this was related to a legal response, and Tim has weighed in on that legal response, Attorney Murphy. So you have that in the form of an in the form of this MOU. So Councilor Hatch, then Councilor Johnston. Councilor Hatch.
Yes, Mr. Mayor, in the spirit of transparency, to avoid an appearance of a conflict, I'm trying to take a lesson from this evening's training. I just want the council to know that my wife and I frequently socialize with Ms. Valentino and her husband. However, when it comes to professional matters such as this proposed MOU, Ms. Valentino and I afford each other the utmost in professional respect and professional behavior. I have reviewed the documentation. I really feel confident that I can objectively and review the package before us and make an unbiased opinion. And I'll go on record to indicate that I have no potential financial interest in this, direct or indirect, and again strongly feel I can make an unbiased decision that serves the best interests of the city of Saco. However, I would defer to you, Mr. Mayor, and my fellow councilors to determine whether or not you're comfortable with me voting on this issue this evening.
Council, is there any objection to Councilor Hatch participating in tonight's vote on this matter? Without objection. Councilor Johnston.
I have no objection. No, my hand's up for the next question or to speak next.
Yeah, we're
okay.
It's to you.
Thank you. Goodness. So I clearly see the memorandum of understanding, though I don't think it really addresses all the issues that I see anyway. And so my first question, I guess is directed to staff, is why the 49 and a half and not the 50 feet width? The issue I have is that Chapter 186 is fairly clear that the city will not accept any road that is not at least 50 feet wide. So I understand that historically the Berry Road is 49 and a half, but the standard is the standard. So, you know, like anything we do, I'm always concerned about, you know, setting precedent with, you know, the next applicant that says, well, I can't make that standard. So again, it hasn't been explained why it's 49 and a half and why we couldn't get the extra 6 inches. I'm curious if we know.
City Planner Hamlin, do you have an answer for that as you've been involved in this?
I will respond in this manner. Having spoken with the city attorney, with the public works director, with the applicant, it is clear, I believe, that this is an unusual situation. It's not every day that the planning board or city council are asked to weigh in on a road that is about 180 years old. It is still being addressed in terms of being completed, as the council knows. A standard measure, and I think this is common knowledge too, was a rod, a three rod wide, tongue twister there. A three rod wide road is 49 and a half feet. I think the city attorney and public works director both are recognizing that not only is this an old public way, an old accepted portion of street, but also an unaccepted and in fact abandoned portion of street. But on the face of the earth, the way is 49 and a half feet wide. Yes, with a significant factor of greater difficulty, the applicant could go out, knock on doors, approach the abutters to Berry Road on each side and seek another 6 inches of width to bring the roadway up to 50 feet. I guess staff and city attorney are not questioning the facility of doing that, but are asking themselves perhaps what's really to be gained. Can a city street be designed and built within a 49 and a half foot wide right of way? My understanding is yes. I would say, Mr. Mayor, that the city attorney focused on what I would call the bigger item issues within the memorandum of understanding. And there was recognition on his part, again, on the public works department's part and on the planning department's part that can a 49 and a half foot wide right of way playing host to what hopefully will be an accepted city street in the near future. Can that function? with no problems? And the answer would be yes, it can.
Thank you, Bob. Councilor Johnston, did you have any follow-up?
I do. Thank you. Well, again, thank you for that clarification. I certainly understand it's a longstanding issue, but the thing that I do think is absent from the memorandum of understanding is the issue surrounding the ordinance that requires a road not be more than 1,500 feet. And here we already have a 4,100 foot road, I believe. And so we're adding to it. Tim didn't address that at all. And he has previously in previous, interactions with the council. So that was an outstanding issue for me. And then the other thing I didn't fully understand was the mechanism of how this is all happening. It appears, and I could be totally wrong, I've read too much on this, but it would appear as though the city is accepting back the abandoned road. Is that accurate? And then Ms. Valentino would develop the road or construct the road once the city owns it. Is that accurate?
Counselor, I would say that is, to the best of my knowledge, that is accurate.
Right.
That portion of the road has been abandoned. If this applicant brings it up to or very close to present day standards, then it will be up to the council at that point as to whether accepted or not.
All right. And so the issue with that is, again, under Chapter 186, the city does not accept roads built prior to 1978. So we'd be accepting back a road that we previously abandoned, which is in conflict with our code. And so my point previously was, again, does this MOU take legal precedence over our code and our zoning ordinance? And that's obviously an issue not for me, or a question or an answer not from me. I want to ensure that if we're doing this, we're dotting the I's and crossing the T's, so to speak. Because again, I think that we could be opening ourselves up in the future where here we are knowingly, we're openly talking about violating these. And I don't know if the MOU is the appropriate legal document, I guess is my point.
Councilor Johnston, could I just clarify, you cited Chapter 186, that the city shall not accept a road built prior to
1978.
78. Okay. Councilor Mayor, I do not have answers for these issues. If the city attorney has addressed that 1,500 foot length issue in the past, I would agree with the councilor that I would like to see Tim's opinion or thoughts on that issue. In terms of the street built prior to 1978, again, my feeling is that Chapter 186 addresses kind of the ordinary or the common subdivision and recently built city street situation very well. I'm not sure that it takes into consideration or addresses at all streets similar to the Berry Road situation. Again, this is an antique of sorts, and certainly the 4,400 feet that are built are, to city standards, are maintained by the city, etc. Now, if another 800 or 900 feet were to be built to current day standards, I don't see a problem with the city accepting something that, could be improved this season. But it would be interesting, again, to run that by the city attorney. And in terms of the MOU taking precedence over code, it crossed my mind to potentially invite the city attorney to sit in this evening. And in retrospect, we probably should have. As we just heard from the attorneys who walked us through some training earlier this evening. When a board, or I would say even a legislative body, feels that there are still questions to be answered, I'm not aware that Ms. Valentino is in such a rush that we couldn't put this off for another week and bring this back either on the 24th or an early meeting in June if the council were open to doing that.
Thank you, Bob. Council Archer. Council Archer, you're muted.
Thank you. I'm hearing what Councilor Johnston just presented, and I do have questions. And again, it sounds like with staff saying we need to bring it back to legal, it doesn't sound like it's going to happen today, unfortunately. But I do have questions that I guess would go for legal review. There is a standard of 50 feet. I understand that, but in a lot of cases, council has. When there's a uniqueness or an X factor, there's allowed to be a slight deviation in some cases. And would the 49.5 foot be acceptable with the understanding that the current road is that distance? We're not talking about it's 49.5 feet. It says all the way to Boom Road. So again, we're just meeting the standards of that road. So is that something we can take into consideration? The second point was about I don't have the date on hand. It was just brought up, but you have the abandoned road and you can't accept the road before 1970, and I might be off by a couple of years. However, when a road's abandoned and you bring it back under the record, does that make it a new road? So again, yeah. So in the sense of dirt or a driveway, yes, it's there. But once that road was officially abandoned and you bring it back onto the records, is that now a new road? Which kind of may address Councilor Johnston's what he presented, and just got my brain thinking. Again, so I'm looking at the uniqueness factor. When the road's already 49.5 feet, what type of leeway do we have to allow it? The extension of the road, what exactly does that mean? I hear that. So there's not much there I'm going to debate on. But again, abandoned road comes back. Is that now a new road? In my opinion, I'd say yes. Once something's no longer in existence, you bring it, it's brand new. And then the last part is it possible to have the applicant speak on any of the questions that are brought up?
That was going to be my next question, Councilor Archer. Does anyone object to Linda Valentino speaking at the meeting?
England, click right here. Click start video.
Linda?
Yes, I'm here.
Welcome. Thank you for joining
Hi.
us.
Thank you very much. I'd like to address a couple of the issues that were brought up. One of them was the why the 49.5 feet. And you, I believe, all had the email from Tim Murphy. It's dated May 11th, 2021. And I'll read directly from that. Having the info on the Jean Hall easements makes it certainly easier to argue to the council that the middle segment of the road, the 880 feet you propose to finish develop, should also be 49.5 feet. If the council agrees to waive the 6 inches of the road standards, all of the Berry Road, the first 4,400 finished feet, the middle 880 feet you complete, and the final 350 feet will all run 49.5 feet in width, from the start of the Boom Road to the terminus at the Foss Road. Forcing the matter to 50 feet wide to satisfy the existing road standard would result in an unnecessary 6-inch bulge in the middle segment of Berry Road. So I can see some wisdom in relaxing the standard here, particularly as it gets an extra 880 feet done. And this was written by Tim Murphy, May 11th. And that was sent to Bob Hamlin, Joe Laveria, and myself from Tim. He also puts in the same email. With all that in mind, attached is a proposed MOU for council consideration. It assumes you will develop the middle 880 feet, but not the final 350 feet. And it assumes a width of 49.5 feet. Also, just basically to address why it was absent from the MOU on the 1,000 feet, basically because this 880 feet already exists. Under your 2005 MOU that a previous city council entered into and a previous city administrator entered into, you agreed to let a developer develop that portion of the road. That portion of the road has been developed so far up to city standards, and it was inspected and has been proved to city standards. So Tim puts also in his letters, all of this is a policy decision for the council, not for me. But I would certainly advocate for this solution if asked. And that's all documented in the email. And I'd be happy, well, I want you to vote on this tonight, but if you don't trust me, there's the email right there. The other thing is, so that addresses the 49 feet, 49.5 feet, the MOU, the mechanism. When you did the 350 feet for Jean Hall at the end of the road, you were granted easements for access over it. You did not accept that portion of the road. So what's happening here with the MOU is only to allow me to seek easements from these people for the city of Saco to do it. It does not accept the road. So you are not, this MOU does not accept this 880 feet as a public road. All it's saying is that we can get the easements for the city of Saco to go across this road the same way you got the easements for the last 350 road. So if anything, it's just bringing up this middle section to have this under the MOU to have the same easements. If the road is completed to city standards and Joe Laveria and Patrick Fox and everybody else signs off on it, and only if it is done to city standards will it then come back to the council, and then you will vote on it to see whether or not it's a public road. This MOU is not committing you to make this a public road tonight. It's just committing you to go ahead and start the process to seek the easements, and it will come back to you. So based on the email from Tim Murphy, based on the policy decision, based on the fact that you did this, a previous council did this in 2005, I'm asking to get started on it. I started asking you in 2017. So I have been patient. We started this back up again in October of 2020. And I would say we've had probably 12 versions of this MOU in the last few weeks. We've gone back and forth. We've wordsmithed it. Patrick Fox has looked at it, Tim Murphy, myself, Joe Laveria, Bob Hamlin. We've all weighed in on it. And I think we've come to a version to know what we're doing to go forward with it. This is not accepting the road. This is basically just saying, go ahead, let's get started. If we can get those easements, that's better for the city of Saco. If the road gets built, well, that's your decision, but that's a decision for another day. This is just saying, go ahead, let's get started. And I would say that I just want to thank Tim Murphy and Bob Hamlin and Patrick Fox and Joe Laveria. They've been great to work with, and we've done a a lot to get it to this point. And I would say that I've tried to, I sell real estate and our mantra is disclose, disclose, disclose. Always tell everything about everything. And I've sent numerous emails to everybody. I've sent them to the city council. I've tried to disclose everything possible that I could to you, been very upfront about everything. And I think based on Tim's email and based on previous MOUs, I would really appreciate it if you could vote tonight to go forward with this. And thank you very much. And I will answer any and all questions you have.
Thank you, Linda. And please stay on with us just in case there are any further questions. Councilor Berman, then Councilor Johnston. Councilor Berman.
Yeah, thank you. I pulled up Saco City Code, Chapter 186, just to familiarize myself with some of these issues. And I'm looking at Chapter 186-34, streets less than 50 foot wide. And it does indeed say that no street or way less than 50 foot wide should be laid out and accepted by the city. But then there's unless the same shall have been actually dedicated and constructed and used for public travel prior to December 8th, 1978. Given the long history of this road of being accepted and then abandoned, I might feel comfortable arguing that some of that applies here. Second, there is indeed Chapter 186-35, which says that no street or way dedicated or constructed prior to December 9th, 1978 shall be accepted, etc. But then there's also an unless. The owners of property adjoining the street shall deed to the city of Saco sufficient land to lay out a street of minimum width, which I think is also happening here. So I'm comfortable that this project meets the standards of Chapter 186 and would be happy to vote on it tonight.
Thank you, Councilor Berman. Councilor Johnston.
Thank you. Again, I didn't sit here and say I was an attorney. That's why I wanted Tim's opinion on these. This is a longstanding issue here. And so this is the first MOU that I've seen other than the 2005 in this particular item. And I personally would have liked more disclosure in it going forward so that we could say this is a very, very particular situation. And this is why we are, potentially looking at some of these, I guess, waivers of code or in other issues, the zoning ordinance, which again, the planning board will have to deal with that. So again, that's just where I'm coming from. I wish that, when we do these things, we would have staff members like Tim Murphy on hand so that I could address these questions to him. Since given the training we had earlier tonight, we're not supposed to be discussing these things outside of a meeting. So I've kind of patiently waited 2 weeks ago when I brought it up, expecting that Mr. Murphy would be here so we could publicly discuss this at a public meeting. And unfortunately, he's not. So if the council wants to move forward, that's fine. Unfortunately, I myself will be voting no because I don't feel I have sufficient legal counsel to have weighed in on this. Thank you.
Thank you, Councilor Johnston. Any other questions, concerns, discussion? Okay. Roll call vote. Councilor Archer?
Aye.
Councilor Purdy?
Yes.
Councilor Gunn?
Yes.
Councilor Berman?
Yes.
Councilor Hatch?
Yes.
Councilor McPhail?
Yes.
Councilor Johnston?
Again, not opposed to the road. Sought more legal counsel that wasn't provided. So no.
Thank you. Motion passes 6-1. Linda, thank you very much for joining us this evening. Have a great night.
Thank you very much, everybody. Appreciate it. Thank you.
That brings us to item E of the agenda, first reading 372 Main Street rezoning request. That is Councilor McPhail.
Thank you, Mr. Mayor. Josh Waterhouse, DBA JW Group LLC owns the property at 372 Main Street, a former doctor's office, currently a 5-unit apartment building. Mr. Waterhouse seeks a rezoning that would enable the number of units within the multifamily dwelling to increase from 6 to 10. The building is in the medium density residential zone. With the new zoning map and ordinance, multifamily dwellings of 3 to 8 units are possible, at a density of 5,000 square feet per unit. 6 units would be possible for the 30,492 square foot parcel. If the parcel is rezoned to high-density residential, multifamily dwelling of 3 to 8 unit buildings and multifamily dwellings of greater than 8 unit buildings will each be a conditional use. The minimum lot area per dwelling unit would be 3,000 feet, so up to 10 units would be possible. The item was reviewed by the Planning Board at its March 30th meeting. After discussion and a public hearing, the board voted to forward a negative recommendation to the council. I move to approve the first reading and to schedule a public hearing for June 7th, 2021.
Motion's been made by Councilor McPhail. Is there a second?
Second.
Second by Councilor Gunn. Any discussion? Councilor Archer?
Yes, thank you, Mr. Mayor. I'm not looking for an answer now, since there's no need to be a rush, but what was the reasoning for the negative recommendation?
Councilor McPhail.
Bob can assist me on this, but during the planning board meeting that night, one of their major concerns was the amount of traffic, which we were provided by Mr. Waterhouse, a traffic study that was recently done providing data. There was also some concerns with regard to the properties behind 372 on Union Street, I believe, Bob, is that correct? That was pretty much it. They all had, they all looked forward to seeing some renovations to it, but I think that those were the two main concerns. And again, one of them has been addressed by Mr. Waterhouse to us today.
Councilor Johnston.
Thank you. Again, I think I addressed this several weeks ago. The challenges that we had with this, going back to the ZORS process, wasn't just the traffic, though obviously that is part of it, I would say, of some members. The issue really started with where the line was drawn. So this previously was R1B, I believe. And so when we went through that process, we selected those zones and we basically applied whatever we were now calling them. So it's now the MDR. And we had those conversations about where these lines should be drawn. We decided, along with the downtown, well, we merged downtown with a different zone, but along with the HDR, we took those zones and merged them into that area. But they still basically followed the same property lines of current zones. So the challenge with this one is, and again, I don't have the map pulled up or in front of me, but the challenge here was that the R1B currently had both this property, the one in between, and what's commonly referred to as the Gregory House, all in that zone. So I'd say pretty much towards the end of I will call it phase one of this process, back in 2018, the fall of 2018, the applicant, I believe, came and requested that his property be thrown into the HDR. And then, conversations continued, and we ultimately decided that if you threw that one in, well, where do you draw a line? Do you now allow the Gregory House and the one in between in it too? And why stop there? So I understand that, obviously it's more favorable to this applicant on a personal level, but, every last one of us that owns property in here can look at it and say, well, I'd like certain things too. So I find it kind of a disturbing trend at this point where we've spent, probably somewhere around $100,000 on a zoning ordinance. And here we are having one-off amendments left and right because certain individuals want to do certain things with their property. And I understand that as a property owner. But again, we being the ZORs and then subsequently the planning board looked at it and said, hey, we should stick with the way the zone was instead of basically cherry picking this individual lot and adding it to the HDR, which while it's somewhat abutted to the rear, but it's not consistent with the other two lots. And that was what we were looking for, was a consistent uniform zoning map. So, I mean, I think that's more of the background there. I think the difference here is 1 or 2 units. So that's all I got. Thank you.
Councillor Hatch.
Thank you, Mr. Mayor. City Planner Hamlin, just a question. We had a trip generation calculation that surfaced dated May 14th, which was last Friday. I'm a little concerned about the due process, and I don't want to be circumventing the talents that are in your office. My understanding, first of all, I'm not quite sure why the trip generation calculation wasn't completed to assist in the decision that occurred at the planning board. That's my first question. And secondly, and you can correct me if I'm wrong here, Bob, if you had received that, would it have not been subjected to some sort of staff review and evaluation and then made part of the record and part of the decision? So I'm feeling a little awkward getting a document that, in my mind at least, unless you can convince me otherwise, would have been more appropriately addressed at the planning board level, as opposed to getting before us at this point and looking at the zone change. So could you, if you could, either clarify my thought process and feel free to correct me if I'm wrong.
No, Counselor, I think you've hit it right on the head. To begin with, I believe that the applicant has gone out and sought this input from an engineering firm, I think pretty much on his own, believing that it might respond to questions that he heard voiced by the council last time. I would also suggest, and I don't know what councilors or Mr. Mayor, what kind of time you had this afternoon, but once Josh had provided this brief traffic summary of the number of trips that would be generated, that have been generated historically by the medical office and the apartments, and would be generated if it were transformed into 8 or 9 apartment units. I replied in asking, okay, interesting information, but how about turning movements? I honestly believe, and I think Councilor Johnston might be able to confirm, that not only was the number of units a concern, but perhaps more so taking left-hand turns out of this property or from Elm or Main Street into this property. For those who are familiar with this intersection, and I'm sure all of you are, very prominent, very busy. It is Route 1 at its finest, so to speak. So Josh did respond that he would be willing to consider limiting turning movements to right turn only. But I would reiterate too what we just heard from Councilor Johnston. I think the planning board was in the unenviable position of having to decide, where do we draw the line? Where can the high density residential zone and where should we draw it back a little bit and make it medium density instead? And so I think when the planning board saw this literally for a third time back at the end of March, as well intended as the applicant is, and I appreciate he believes he's got a very justifiable request here. I think the planning board had seen enough and didn't take long to come up with well, we decided this once already and we're going to stick by our guns.
Councilor McPhail.
Thank you, Mr. Mayor. And, Councilor Johnson is correct. And with respect to the work that the ZORs did, and I do understand, the difficulties and where does the draw line. But we as the council, again, we do have the options of these contract zones to review and where needed. And we do have certain issues or items that come up, such as this one that for me personally, I think this is positive. I look at a building that is a historic building that has been in Saco for years, which has been unmaintained and has become an eyesore on Main Street. And for somebody to want to take that property and redevelop it, following the comprehensive plan for our downtown, we are looking for the density areas and taking and refurbishing an existing older building is all positives to me. So.
Council Archer.
Yeah, thank you for being so objective on this, Bob. Was it a unanimous decision or a negative recommendation?
Oh, boy. I believe it was, Counselor, but let me take a look in the at those minutes, and that should tell me something. If the council cares to continue its discussion, let me check on the minutes and I can get right back to you.
Council Archer, you have your hand up. Is that from before or?
Yes, it was.
Any further discussion on this while Bob checks the minutes? Council Archer.
Yes, thank you. This last question just helped me think that maybe we can, is it possible in the future for staff to add to the recommendations, the actual voting? Not by whom, but just a number?
Counselor, it certainly is. And I can confirm, indeed, it was a unanimous vote by the planning board.
Okay, thank you very much.
Yes.
Any further, Councilor Berman?
Yeah, thank you. Would it be possible to put in a stipulation limiting it to right turns only before the final reading? And how would we do that?
In my perspective, Counselor, the council certainly can make that stipulation and include it in the motion, and that is the way it will be. This project, when an existing multifamily building is proposed to be expanded, so to speak, even if it's within the same footprint. So in this case, going from 5 units to, I believe, the proposed 8, that triggers the need for site plan review. So it's a guarantee this will be coming back to the planning board. And if that's the direction provided by the council, the board will be made aware of that.
Any further discussion? Remember, it's first reading, so public hearing would be down the road. Roll call vote. Excuse me. Council Archer.
No.
Councilor Purdy.
Yes.
Councilor Gunn.
Yes.
Councilor Berman.
Yes.
Councilor Hatch.
Yes.
Councilor McPhail.
Yes.
Councilor Johnston. Councilor Johnston, you're muted. I don't know if you gave an answer.
Yes.
Okay. Motion passes 6-1. That brings us to item F on the agenda, one reading property foreclosures. Councilor Purdy.
Thank you. Give me a moment to scroll back down to it here. The city foreclosed on several properties on January 23rd, 2021. Many attempts have been made to get to the property owners to either pay off matured tax liens or enter into option agreement and remain current with them. All attempts were unsuccessful. Be it ordered that the City Council authorize the Finance Director to write off the delinquent tax amount for the identified properties and remove them from the tax rolls to hold on further action as recommended, and further move to authorize the Finance Director to conduct additional research on those properties that qualify for disposition. I move to approve the order.
Motion's been made by Councilor Purdy. Is there a second?
I'll second.
Second by Councilor Hatch. Discussion? Councilor Archer?
Yes, again, we have some new counselors on board, so I just wanted to offer some, the reason why I'm going to be voting for this as written is I asked this question a while back ago. So this one's related to the reserve circle, in which we're going to be writing off $282. Since it's a trailer and it's been demolished, we can't lien against it. There's no actual legal way of getting the money other than tax collection, and we'd be losing all of that value just trying to collect it. So in this case, I'm going to be voting for this as written, but again, this is a thing that we cannot collect on since that product or that trailer does not exist.
Thank you, Councilor Archer. Any further discussion? Roll call vote. Councilor Archer?
Aye.
Councilor Purdy?
Yes.
Councilor Gunn?
Yes.
Councilor Berman?
Yes.
Councilor Hatch?
Yes.
Councilor McPhail?
Yes.
Councilor Johnston?
Yes.
Motion passes 7-0. Brings us to item G, one reading, approved collections policy. Councilor McPhail.
Thank you, Mr. Mayor. The police and finance departments have worked to establish a procedure for tracking cash evidence that improves security by allowing the police department to deposit cash evidence into the city's bank account after being held for 2 weeks. Tracking protocols ensure cash evidence that is claimed can be dispersed upon request. Be it ordered that the City Council approve the amendment to the billing and collections policy. I move to approve the order.
Motion's been made by Councilor McPhail. Is there a second?
I'll second.
Second by Councilor Berman. Any discussion on approving this collections policy changes? Seeing no hands raised and no councilor seeking recognition, roll call vote. Councilor Archer?
Aye.
Councilor Purdy?
Yes.
Councilor Gunn?
Yes.
Councilor Berman?
Yes.
Councilor Hatch?
Yes.
Councilor McPhail?
Yes.
Councilor Johnston?
Yes.
Motion passes 7-0. That brings us through the action items. We get to item 10 of the agenda, new business item. Item A, 507 Main Street Contract Zone. And I believe we will be hearing from Director Clavette. Or City Planner Hamlin, will you be
Bob, you were muted.
Welcome back. Yes, Bob Hamlin will be working on this one because it is a contract zone, but I'm here to talk if needed for 507 Main Street.
So any questions from the council on preliminary? Bob, did you want to go through and kind of go over the highlights, and Councilor Johnston?
I mean, Bob can go ahead.
Okay.
Yes, I'd be happy to. Thanks. I'm just trying to get to my place in the packet here. One moment. But generally, Mayor and Council, I would bring to your attention that this is a little out of the ordinary, only in terms of the sequence of events. As allowed by the zoning ordinance, a contract zone applicant may initiate site plan review concurrently with the contract zone review. Most applicants in the city's experience want to make sure that they successfully navigate the contract zone review process before initiating site plan review. I suppose it's a measure of this applicant's level of urgency, if you will, to be embarking on the site plan review ordinance tomorrow night with the planning board, while this evening is the first time that the council sees the contract zone application. So with that said, the applicant has been through the planning board, in fact, earned a negative recommendation in terms of utilizing the contract zone process to allow what is a proposed multi-tenant commercial building on the parcel at 507 Main Street. Most of us know that piece of property as the Pizza Hut parcel. The existing Pizza Hut building would be demolished. The current applicant, once successfully, again, navigating the contract zone process and then site plan review with the planning board, proposes to put up about a 5,300 square foot building. Currently, they propose the one name that I know has been mentioned publicly would be a Chipotle Mexican grill. I believe it's referred to as. A drive-through window is sought as part of the Chipotle operation. Secondly, I believe another food operation. And then thirdly, the space would be retail. So in general, the zoning for this stretch of Main Street is adequate to allow this sort of thing. I recognize that the applicant was a bit taken aback that there's a situation with a fast food restaurant where it is not your classic Webster's Dictionary definition in the zoning ordinance of what you would see for a fast food restaurant. In fact, it makes clear that food prepared quickly for either on-site consumption or to take away that food and consume it off premises. But it makes clear too that a drive-through window is not part of that situation. Well, an eating and drinking establishment or an eating establishment are allowed uses in the highway business district that we're speaking about. Separately, a drive-through window is an allowed use that must also be reviewed by the planning board. But bottom line, the applicant simply wanted to clarify that indeed an eating establishment, the Chipotle, with a drive-through window could be established, and they decided that doing that via a contract zone made sense. Additionally, current zoning standards, councilors and mayor, require that a commercial building of this sort be brought up closer to Main Street. And recent examples, for instance, might be the Convenient MD just across Main Street, or the Biddeford Saco Dental building that was constructed, in the past year and a half. The ordinance simply encourages buildings to be brought closer to the Main Street right of way in an effort to make it feel like a more human scaled street. Evidence is that traffic tends to go slower if buildings are brought up a little closer, and the feeling of somewhat more narrow roadway is what motorists experience. In this case, the applicant proposes to amend that, and they would like, as is true with the existing Pizza Hut, to take advantage of having 2 rows of parking spaces between the building and Main Street. And thirdly, the drive-through line going around to the northerly wall of the building. In the ordinance, there's a requirement that parking spaces and travel lanes must be set back no less than 5 feet from a property line. The design of the project has that being set back perhaps 3.5 feet from the property line. So they're working with a fairly tight site here and recognize that they can make the drive-through line work, but it's going to be a little closer than 5 feet from the line. So they're seeking a reduction in that setback. So that, in a nutshell, is what the applicant proposed a couple of weeks ago with the planning board. There was a good deal of discussion on the board's part. There were a number of members of the public that participated in the public hearing. At the end of that evening, again, the board voted on forwarding a negative recommendation. They simply did not agree with some of the requests put forth by the applicant. A bit more, and I appreciate your putting up with my long-windedness here. I simply bring this to the board's attention because I think it has become front and center as part of this application. The parcel in question is deep enough from Main Street back to the rear of the property that, as designed, the building and the parking lot go back to a certain point and leave about a 50-foot wide strip of land. We can go back to the 2005 Main Street Access Study. We can go back to the 2011 Comprehensive Plan, both of which encourage the development of local streets and access ways parallel to this section of Main Street as a way of taking the pressure off Main Street and diverting some traffic to these parallel ways. Most of us are familiar with the McDonald's Hannaford situation across Main Street from here, wherein the public can utilize what is private property via an access easement between Hannaford and McDonald's. This is proceeding along the same lines. The planning board discussed this at some length, recognized the value, I believe, in the possibility of some sort of access drive and or potentially a full-on city street that would connect the rear of the proposed Chipotle parcel from Smith Lane northerly up to Stockman Avenue. It would be at the rear of the Dunkin' Donuts, the Starbucks, the IHOP properties, and come out onto Stockman, in fact, across a city-owned parcel. City staff, the Public Works Department, planning boards over the past literally 15 years have all been aware of the potential for this. Only rarely does the opportunity present itself. And with the redevelopment of 507 Main Street, again, that's a front and center issue. The applicant heard that and I think got the message very clearly from the planning board. I commend the applicant for putting together a draft easement agreement. I believe that's in the board's packet, in the council's packets, excuse me. I think it does bear some further discussion. I can tell the council that while the applicant is approaching site plan review tomorrow night with the planning board, there's still much to be talked through. So almost certainly this will not be wrapped up tomorrow night with the planning board. And of course, we have a few meetings to go with the city council. Apologies for going on at length as I have here, but I think that gives a reasonable overview of what's happening, and I'd be glad to answer any questions.
Thank you, Bob. Councilor Johnston.
Thank you.
Yeah, so I spoke at the public hearing on this, and I stated at the time that it was, agreeable to the relief from the zoning ordinance that they requested, but the easement was an absolute must for myself anyway. And I think that's really where largely the negative recommendation came from the planning board. So I was pleasantly surprised to see this easement agreement. The only question I have for the city planner is, I know I've seen several variations of things drawn on maps over the years. Has the city, and really by the city, I mean, Joe, city engineer, has he actually gone out there and figured out if this is doable at all, or is it still more of a concept on paper? Because again, I would obviously like the easement, but I also want to make sure that it's somewhat functional. And then the other question I have is the current properties that are there with used to be Pizza Hut and it used to be Taco Bell, now Starbucks and Dunkin' Donuts. They had an easement agreement that dates back to like 1989, and then it was amended in 97, I believe, when Taco Bell went in. But when I looked at, and I definitely recognize this is all preliminary and hasn't got a site plan, so perhaps it comes up there, and I guess that's why I'm mentioning it, because maybe you could ask this. The site plan drawing that is in our packet, it looks like it's moving the current easement that's in place, and I'm just curious if that easement will continue, because I know that there would be several properties owners that are over there that would be upset about that. I'm assuming it is. I just was curious because I did notice that it looks like that access is being moved over to the right. Thank you.
Yes, Counselor, the site plan I'm looking at, and I believe it's the same as council is looking at. Yeah, there is a cross easement that is being preserved with the abutting property, certainly with the Starbucks property. But that, I agree, that bears a little further investigation, and I appreciate your mentioning that. That'll be brought up with the planning board, and we will determine what the current situation is. And in terms of what the city engineer's opinion of all this is, I had asked Andrew, who is running our Zoom programming this evening. We passed on what is Joe LaVerrier's most recent sketch of what's possible out there. Could I ask, Andrew, would you be able to put that PDF up on? Thank you very much. So on the left end would be the southerly end of this proposed easement. You see the red roof of Pizza Hut, can't miss that. So indeed, this rear access drive, potential future city street, would simply go across. Nearly half of this would be, in fact, the applicant's property at 507 Main. It would clip just a corner of the IHOP property, duck down across what is the Ledges property, and then come out onto Stockman across that, as mentioned, a city-owned property. So that is a fortunate situation there. But two other things I think are important. Nothing at all preventing customers of Dunkin' Donuts, Starbucks, and certainly IHOP of utilizing this future way. Public access would be critical to it, of course. So for customers to either visit those businesses or depart from those businesses via that rear access, again, just takes a little bit of pressure off the busy Main Street. Secondly, and the city engineer would be the first to explain this, the property is in the Bear Brook watershed. Bear Brook runs into Goosefair Brook. Goosefair Brook is an urban impaired stream and watershed as identified by the Maine DEP. Not only does this access drive present itself for transportation issues, but there are a few stormwater detention facilities that simply have not been particularly well maintained over the past several years. So this could present an opportunity for great improvements in that fairly critical environmental sense as well. So hopefully this graphic, which was drawn by the city engineer, gives councilors a pretty good idea of what's possible out here.
Any Council Archer?
Yes, thank you, Mr. Mayor. That last photo or the last image with the road, I couldn't read it, but 9 Stockman, is that correct? Is what the city owns?
Ooh, Counselor, I do not know, so I'm not going to guess, but that would make some sense. I just don't want to guess at what that street address is. I'm not
So this
sure.
would just be a question, but where it does say City of Saco, that looks like it's using up a majority of that property. Are we selling the property?
No,
I
in
would
fact,
hate to give an easement for taking pretty much the whole property.
yeah, nope. My understanding is that the city has owned the property for a number of years. In fact, it is pretty utility heavy, if you will. To the best of my knowledge, there's a fairly significant sewer line in there. There may be an existing stormwater line there as well. This has come up in the past and included Pat Fox, Howard Carter, and others. So I think it's kind of a pivotal city-owned parcel that that certain city department members would be reluctant to part with simply because it's already encumbered by a lot of utilities.
Okay, thank you.
Any further questions on 507 Main Street Contract Zone? Councilor Gunn, you're the counselor of record. Are you willing to make the motion when it comes?
Most certainly, yes.
Thank you. If there's no more discussion, we'll move on from this. Okay. Moving on from new business and coming to item 11, administrative update. City Administrator Canrath.
Thank you, Mr. Mayor. A reminder, absentee voting for the June election is now underway. Voters may request an absentee ballot by phone by calling 284-4831 or by downloading the application at sacomaine.org under City Clerk Voting and Elections. You may also vote in person at City Hall between the hours of 7:30 a.m. and 4 p.m. And we will have 2 days of extended voting on June 3rd until 6 p.m. and on June 4th until 5 p.m. And voters may also utilize the ballot drop box located on the Cutts Avenue side of City Hall that was new in the past year. Senior meals on May 13th, we again served over 250 meals. Thank you to everyone involved, all of the volunteers there. We will have one more additional day in June coming up. They'll have more details on probably next week. Another reminder, my city administrator's open office hours next session will be May 25th, 3 to 5 p.m. on the second floor of City Hall. Of course, all residents and local business owners are welcome and encouraged to attend. Lastly, I did just want to say thank you to everyone involved in putting together and passing our fiscal year 22 budget at our last meeting, to the council, the city staff, and in particular, our finance director, Glenn Salas, for an outstanding job. I thought the whole thing was orderly, it was smooth, and I thought it made us all look pretty good despite the difficult circumstances that we found ourselves in during the pandemic and this year. So I thought we had a pretty good product at the end, and it was a very smooth process. So thank you to all involved there, and that is done for another year. That's all I have. Happy to take any questions.
Any questions at this time? No questions. Moving on. Council discussion and comment, item 12. Any council discussion and comment tonight? Council, I just want to give you a heads up. We are looking at going back to in-person meetings beginning in June. Back to in-person meetings beginning in June. Obviously, that's subject to change depending on what happens out of Augusta, but presently that is our hope. Councilor Johnston.
Oh, thank you. In the near future, could council get an update? I'm assuming this will probably be done in executive session, but on the Route 112 corridor upgrades, I'm starting to hear a lot of scuttlebutt, and I'd like to be informed. Thank you.
Okay. Anything else under council discussion and comment? Okay, we're moving on to item 13, executive session. Is there someone willing to make a motion?
I will, Mr. Mayor.
Councilor McPhail,
Be it ordered that the city council enter into executive session pursuant to M.R.S.A. Title I, Chapter 13, Subchapter 1, 4056. Consultation with legal counsel.
motion's been made by Councilor McPhail. Is there a second?
I'll second.
Second by Councilor Berman. Discussion on going into executive session? Any discussion? Roll call vote to enter executive session. Councilor Archer?
Aye.
Councilor Purdy?
Yes.
Councilor Gunn?
Yes.
Councilor Berman?
Yes.
Councilor Hatch?
Yes.
Councilor McPhail?
Yes.
Councilor Johnston?
Yes.
Motion passes 7-0 at 9:46. Folks, just give yourself about 5 minutes to take a quick recess as we migrate over to the link that Brian provided for executive session. Okay, welcome back, everyone. Is there a motion to exit executive session?
So moved.
Councilor Hatch, is there a second to exit executive session?
Second.
Councilor Purdy, any discussion? Roll call vote to exit executive session. Councilor Archer,
Aye.
Councilor Purdy,
Yes.
Councilor Gunn,
Yes.
Councilor Berman,
Yes.
Councilor Hatch,
Yes.
Councilor McPhail,
Yes.
Councilor Johnston.
Yes.
Motion passes 7-0 to exit executive session at 10:10. Is there any report from executive session?
No report.
No report from executive session. That brings us to item 15. Is there a motion to adjourn?
So moved.
Councilor Archer, is there a second?
Second.
Second by Councilor Berman. Discussion. Roll call vote to adjourn. Councilor Archer,
Aye.
Councilor Purdy,
Yes.
Councilor Gunn,
Yes.
Councilor Berman,
Yes.
Councilor Hatch,
Yes.
Councilor McPhail,
Yes.
Councilor Johnston.
Yes.
Motion passes 7-0 to adjourn at 10:11 p.m. Thank you very much, everyone. Have a wonderful evening. Take care and stay safe.
Good night.